Hello, is IT there?
Hi, Luz. How you doing?
Good. Who's this?
Sasha.
Oh, Sasha. So what do? We just unmute and unvideo ourselves until it's our time. This is the first time I'm doing this.
Correct. When it's your time to speak, you can unmute and turn your video on. If you forget to do so, I am also monitoring and can do it for you.
Oh, okay. So when Jeff says now, I'll pass it on to Liz Benetti. I can unmute myself and put my video on. That's it.
Correct.
Okay. Thank you.
All right.
Hey, Sasha.
Go ahead.
Oh, quick question. I can reduce this down so I can see my notes as well, right?
Yes.
Okay. Under view.
I don't know the actual.
Okay. Never mind. It's okay. I'll just work through it.
Okay.
All right, good morning, everyone. We'll go ahead and get started here. It's Thursday, April 15th, 2021, and this is the meeting of the California Fair Political Practices Commission. Ms. Linker, would you please call the roll?
Commissioner Baker?
Here.
Commissioner Cardenas?
I'm still here.
Commissioner Wilson?
Here.
Commissioner Wood?
Here.
Forgot.
Chair Matich.
And I'm still here too. All right, good morning, everyone. We'll begin with item number 1. This is public comment for items not on today's agenda. Do we have any public comment on the telephone for items not on today's agenda?
Yes. Are you able to hear me?
Yes, we are. This is the time for public comment for items not on the agenda today.
I understand that very well. Thank you. I'll start my 3 minutes now. This is Steve Petzold in Santa Clarita, California. On April 5th, I received a letter from the Enforcement Division advising me that they had decided not to attribute the contribution to the foundation from the Santa Clarita Community College District. I found that very strange for several reasons. First, on the 460s filed by the committee, it identified the Santa Clarita Community College District and the COC Foundation as the source of the 3 contributions. In stipulation 17-287 approved by the commission in June of this year, the Enforcement Division identifies the Santa Clarita Community College District as a major donor of $50,000. As you know, later on, I found 3 warrants with the name of the Santa Clarita Community College District on them. Now, the FPPC, to the best of my ability, only regulates the misuse of public funds as related to campaign mass mailings. So the question is who, not the source of the funds, but who should get the credit for the contribution? These funds were under the control in the account at LA County Office of Education of the Chancellor of the Community College District. The foundation has no ability at all to disperse funds by itself from the funds that have been aggregated that in the LACO account. I ask you to refer to Campaign Manual 2, Chapter 3.5. So the committee failed to identify a single entity for the credit of the contributions. And reading from the manual there, it says that a series of contributions from significant contributions from a nonprofit organization or MPO that are not registered as a political committee on the Secretary of State's website should be suspect. I believe that the funds that went to the committee should be attributed to the Santa Clarita Community College District and not to the foundation. I believe that this is very important for you to consider as we move on into the next items, because it looks to me as if a decision was made not to work the facts to abrogate the community college district from making the contributions. So I think that in following your own guidelines, the contributions to the foundation should have been attributed to the community college district, not the foundation. Thank you very much.
Thank you, Mr. Petzold. Do we have any additional public comment, again, for items not on today's agenda?
Yes, Chair Matich. This is Hossam Haggag from the City of Santa Clara.
Good morning.
Good morning. Hello, everybody. I am Hossam Haggag, the City Clerk and Chief Elections Officer for the City of Santa Clara. Back in September, I wrote and presented to you about a very serious case of dark money in the City of Santa Clara in the matter of Blue Pack and Douglas Chan, which was on the September 2020 agenda. Thankfully, when I presented critical evidence to staff back in September in preparation for the hearing, they diligently requested a continuance and have been working very hard over the last 7 months on the new evidence that I've been providing them. I want to commend staff for all of their hard work on such a critical case. There's only two things that I'd like to bring to your attention today. The first is I sent an email to the commission and to staff highlighting my concern about the impending expiry of the statute of limitations for this case. And while I don't want to go into the details of the case so as to not prejudice the commissioners before hearing the case as officially presented by staff, I want to express my concern about the 5-year statute expiring, as this dark money violation happened during the 2016 general election. Clearly, there's a lot of evidence and there's probable cause that allows the FEPC to investigate and complete the investigation before the statute expires, or allows them to stay the statute given the abundance of evidence with probable cause. In fact, as I was preparing for my remarks this morning, I've come up with new information and evidence that I emailed to staff in addition to the plenty of evidence that they already have. And again, I want to commend staff. I was on the call with Enforcement Chief Brereton last week, going over some of the evidence that I had emailed. Of course, today morning I shared additional evidence, which brings me to my second point, which is, I as the Chief Elections Officer in Santa Clara am offering my services to staff and to the commission because I care about dark money. It's my job. I take it seriously. I know you all do as well. And of course, I commend all of the hard work from staff, and I'm making myself available for any assistance on this case. So I just wanted to bring up those two issues. Of course, with the statute expiring, the 5-year statute expiring soon, I'm looking forward to seeing this being officially placed on the agenda with the new evidence presented before the statute expires, whether with the final determination from staff or at least a stay on the statute with probable cause. Again, thank you all for your time.
Thank you, and I do look forward to staff presenting it to us at the appropriate time following the completion of their investigation. So thank you. Do we have any further public comment for items not on today's agenda? Hearing none, we'll proceed to item number 2, approval of the March 2021 Commission hearing meeting minutes. Do any commissioners have questions, comments, or edits for the meeting minutes? Hearing and seeing none, do we have a motion to approve?
Move to approve them, please.
I'll second.
Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. Now proceed to our enforcement consent calendar. We have 2 items on the consent calendar today. Do any commissioners wish to pull for separate discussion either of the items on the enforcement consent calendar?
Yes, Mr. Chair, I would like to pull item number 3 in the matter protect the City of Commerce, sponsored by California Commerce Club, from consent, please.
All right, thank you. And I apologize for the sake of the other commissioners. Ms. Nakano, our legislative counsel, she has just reminded me she has a hearing she needs to testify at 10:30. So I promised her we would take her first today. So sorry, I jumped ahead to the enforcement consent calendar. At this time, I'd like to actually move to our legislative report. And Ms. Nakano has a hard stop at 10:25. So we have about 15 minutes with her.
Thank you, Mr. Chair and Commissioners, and thank you for your flexibility with the order of today's agenda items. I have a few updates on the status of Commission-sponsored bills, and I'll bring up 2 additional bills that the Commission may wish to support. First, SB 686, a Commission-sponsored bill by Senator Glazer relating to LLC disclosure, was heard in the Senate Elections Committee this past Monday. The bill passed out of committee with a vote of 4-1, with Senator Nielsen voting no. The bill has support from the League of Women Voters, and the California Chamber of Commerce submitted a letter in opposition. AB 236 by Assemblymember Berman, also Commission-sponsored and relating to LLC disclosure and currently identical to SB 686, will be heard in the Assembly Elections Committee today. AB 1367 by Assemblymember Lowe, another Commission-sponsored bill, is also being heard in committee this morning and has been proposed for consent. Per the author's office, the bill will be amended to remove the one bank account provisions and to retain only the increased penalties for egregious personal use of campaign funds. There were some questions and concerns from stakeholders, and if staff is able to resolve those concerns, the one bank account provisions may be added back into the bill at a later time. And I'll pause here and ask if the commissioners have any questions on the commission's priority bills.
Commissioner Baker?
I just have one. Thank you, Ms. McConnell, both for, again, an excellent overview in the memo, as well as the responsiveness to additional requests that I had leading up to today's meeting. With respect to the SB 686, we did receive the feedback from not only Chamber of Commerce, but I understand you've met with individual groups as well that gave their feedback. And I wonder if the author of the bill, or if we as a commission might be interested in discussing the threshold that triggers the reporting. Right now it's at $1,000, which is maybe considered low, and perhaps we might want to look to something that would be a higher threshold to make sure that we're still focusing on where we want to focus, but maybe not catching so many smaller entities. I don't know that that will address all the concerns of the Chamber of Commerce, but in terms of my own concerns, that it's a low threshold. Do you have any thoughts on that? And I welcome other commissioners' thoughts.
The $1,000 threshold is something that is a fairly common threshold under the Act. It's used for recipient committees and for reporting in other areas. So it's an area where there is some precedent, but I think that there is room for discussion about that figure.
Yeah, and for my own part, I think the Chamber's letter does identify some concerns with the threshold. I think this is a commission-sponsored bill, and I know staff spent significant time looking at whether the states have done what they think the best approach would be. But I would say, for my own part, I'd be open to a stakeholder offering some friendly amendments around the area of the thresholds and perhaps the look-back period too. Currently, the bill, it's, if you contributed $1,000 within the prior 2 calendar years. To my mind, one of the things I know we're most concerned of is when LLCs come in shortly before an election and they're used essentially as a conduit for dark money into our elections. And I suspect that probably isn't happening 2 years before the election. It's probably happening closer in proximity to the election. So if a stakeholder had ideas on how to perhaps shorten that period of time, I'd be willing to entertain it. But my expectation would be that would be a proposal that would come to us for consideration. Do other commissioners have thoughts on that? All right, hearing none, I think Ms. Nakano, the feedback then is we are open to other ideas and we'll consider them once those ideas are presented to us.
Thank you.
Mr. Chair.
Commissioner Cardenas?
Mr. Chair, if I might, I have a question relating to another part of Ms. Nakano's report, if I may.
Hang on, Ms. Nakano, were you going to move to the other portions of your report after this, or just in terms of your timing?
Yes, I have 2 other bills that I am planning to discuss, so I can bring those up first, and if Commissioner Cardenas still has questions after that, I'd be happy to take them.
Would you mind, Commissioner Cardenas? Just thank you.
Please.
Thank you, sir. Appreciate it.
Proceed.
Okay, I'll move on to the 2 other bills. The Law and Policy Committee met on Tuesday and voted to recommend that the Commission adopt a support position for both of these bills. The first is AB 1590, which was introduced on March 18th. It's a bill by the Assembly Elections Committee and is an Omnibus Political Reform Act bill. The bill currently contains 2 sections, one of which makes non-substantive corrections, and the second which would transfer the duty to collect the penalty for failure to pay the annual committee fee from the FPPC to the Secretary of State. And the Secretary of State is currently responsible for collecting the original fee. The Commission, under this proposal, would no longer be involved in enforcement of this provision. This section was included in the bill at the request of Commission staff, per the direction of the Commission late last year to pursue this proposal. And I'll pause now for any questions that the Commission might have about this bill.
questions on Assembly Bill 1590 from the Commission? Commissioner Wilson.
Yes, thank you, Ms. O'Connell, for your excellent presentation. Does the Secretary of State's office have a position on this bill?
They are neutral.
Okay, thank you.
Any additional questions on AB 1519 for Ms. Nakano? Hearing and seeing none, please proceed.
Okay, the second bill is AB 319 by Assemblymember Valladares. This bill would prohibit a foreign government or principal from making contributions, expenditures, or independent expenditures in connection with the election of a candidate to state or local office, and would prohibit the solicitation or acceptance of those contributions. Existing state law currently prohibits these foreign contributions and expenditures if they are made in connection with a state or local ballot measure. So this extends it to contributions in connection with the election of a state or local candidate. The prohibition added by this bill currently exists at the federal level. Federal law prohibits foreign nationals from making and persons from soliciting or accepting contributions to federal, state, or local elections. Federal law applies to foreign nationals, and state law applies to foreign governments or principals. Under the definitions for those terms, this means that state law does not apply to individuals who are legally present in the U.S. According to the author's office, AB 319 is needed because the FEC, which administers the prohibition at the federal level, is extremely backlogged and deadlocked and is not enforcing the federal prohibition. AB 319 would allow the FPPC to enforce this prohibition even if the FEC does not. Relevant to note, this proposal originated with the Commission's Enforcement Division in 2016 and has appeared in former legislation, including AB 2250 in 2016, which the Commission supported at that time. The bill has support from Common Cause as well as the Election Integrity Project, and is also being heard today in committee and has been proposed for consent. Staff on the bill reached out and asked whether the Commission would support the bill, and I'd be happy to take any questions.
All right. Thank you, Ms. Nakano. Any questions for Ms. Nakano on AB 319?
Does the commission have a position on this bill?
The Commission's Law and Policy Committee recently voted to recommend to the full Commission that we vote to support this bill.
The Federal Elections Commission has been remarkably deadlocked for at least the last 2 years. You go onto the website to see what activity has been done there. There's been virtually none for the last 2 years. That makes complete sense to me for what it's worth.
Thank you, Commissioner Cardenas. Any further questions for Ms. Nakano on AB 319? All right, Commissioner Cardenas, I know you had a question for Ms. Nakano on another portion of her report, and mindful that we only have her for about another 5 minutes, wanted to give you an opportunity to ask that question.
Thank you, Mr. Chair. Ms. Nakano, good morning. My question should only take about 15 minutes to get through, I think. Yep. Ms. Nakano, among the commission-sponsored bills or hoped for bills is in the area of lobbyist audits and reports. Are there any prospects that we might find a taker for that one?
We're working with Senator Allen's office. He has a bill that's been introduced now on lobbying reports, and they have some similar goals. We don't know yet what they'll be willing to take from our proposal, but we are in conversations with them and are looking for other avenues to get that proposal in legislation this year.
Thank you very much.
Ms. Nakano, anything further from your report that you wanted to highlight for the commissioners in your remaining time with us?
No, I think given my limited time, that'll be it.
All right, great. So as I read your report and understand your presentation, we are being asked today to vote on potentially taking a support position on two bills. That's AB 1519 and Assembly Bill 319. So before we move to that vote, I wanted to call for any public comment on either AB 1590, or AB 319. Is there any public comment on either of those bills? Hearing and seeing none. Let's take AB 1590 first. Do commissioners, any commissioners wish to make a motion to support AB 1590?
I'll move to support it.
Second.
Commissioner Wood? Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Manich?
Aye.
The motion passes.
Thank you. Now moving to AB 319. Again, we've been asked to take a support position on that bill. Do any commissioners wish to make a motion to support AB 319?
So moved.
So moved. Second, Mr. Wilson.
Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Manich?
Aye.
The motion passes.
Excellent. Thank you. Any further questions or comments from the commissioners for Ms. Nakano in the remaining 3 minutes that we have her here this morning? Hearing and seeing none. Ms. Nakano, you can get that cup of coffee before you move to the committee hearing. Thank you very much for
Thank
your
you.
presentation this morning. All right. So we will now return to items 3 and 4. This were the commission's consent agenda. Commissioner Baker had requested that we pull item 3 for separate consideration. So at this time, before we proceed to item 3, is there any comment or questions for Chief Brereton on item number 4, which is the only remaining matter on our consent calendar? Hearing and seeing none. Do we have any public comment on item number 4 on the consent calendar?
Yes.
Yes. This is Steve Petzold out in Santa Clarita, California. When this item was heard originally back in August, Commissioners Cardenas and Hatch had indicated that they were concerned that no natural persons were named. I will note that in this stipulation, again, there are no natural persons named. And that was because it was determined to be a major donor committee and not a recipient committee. Now, I believe that this committee should have been deemed a recipient committee because the funds came from donations from Barnes & Noble and Pepsi Bottling. The contracts themselves that were with the district refer to those as donations and sponsorships. So I don't know exactly how the Enforcement Division can call funds that are referred to as donors and sponsors as non-donor funds for the purpose of not considering it as a recipient committee. There was strong involvement of the foundation in this committee. As you may have noted, I re-listened to the hearing, and the attorney for the respondent indicated in her remarks to the commission that the committee had been sponsored by the foundation, and the foundation had hired a CPA to administer the committee. So if that is the case, then perhaps all the contributions, we don't know whether he was, the PO was compensated or not. So by an admission against the interest by the respondent's attorney, it appears that there was involvement by individuals in the foundation that should be held accountable for the management of the committee. So I just don't know how you can come to the conclusion that this was not a recipient committee and use exclusively non-donor funds when the contracts with private companies required that donations be made to the foundation. I'm asking you to table this stipulation, turn it back to the Enforcement Division for a determination as to whether this is a recipient committee, and in the eventuality it is or it isn't, that you have a full evidentiary hearing before an administrative officer. This provides a blueprint to other public agencies how they can avoid FPPC rules and regulations. I consider this to be very important, and I ask for you to use your authority to regulate how these funds were administered and what kind of committee this is, and I thank you.
Thank you, Mr. Petzold. Do we have any additional public comment on item number 4?
Yes.
Please proceed.
Can I be heard?
Yes.
Okay, thank you. In March 2016, the board of the foundation held a meeting. At the meeting, it publicly announced its support for Measure E. The minutes are silent as to authorizing a contribution for any amount. Over the next several months, 3 contributions of $50,000 were accepted by the committee. The requests for each of the checks were made by the district chancellor. The requests were authorized by the chancellor and the district financial officer. The warrants to issue checks were authorized by the district board. The committee ultimately reported donations that were allegedly from the foundation. The drawer was the county treasurer, the drawee was the county's bank, the payee was the committee. That's basic uniform commercial code checks. It is also only through accounting entries allegedly at LACOE that the true source of the funds can be determined. To date, those accounting entries are hidden from the public. The foundation's lawyer's only obligation and duty is to the foundation, not to the district, not to the public. The lawyer now claims that the source of the funds were 2 district vendor contracts. Vendor contracts are a source of district revenue. The contracts expressly required a gift of district revenue to the foundation as a condition. The contracts expressly gave the chancellor exclusive use and control over the funds. A district employee runs all the day-to-day affairs of the foundation, such as depositing donation checks. The funds are not reported as donations or other taxable income in the foundation's financial statements. The funds are not reported in the district's financial statements. But for the whistleblower tip, the vendor contracts would never likely have been revealed. If the bundle of sticks that represent legal ownership of property are the concepts of use and control, an objective observer, this commission might ask, who had exclusive use and control of the funds at issue? Has the foundation ever exercised ownership over any funds derived from the contracts? Where have these funds ever been publicly accounted for? Why hasn't the Enforcement Division issued subpoenas to the foundation, the district, the LACOE, and the county treasurer for their records? An objective observer might conclude that the chancellor had created a scheme to funnel public money into a special off-the-books account over which only she had control, and that she exercised that control to benefit a political campaign to extract hundreds of millions of dollars from an unsuspecting public. Money laundering is the process of hiding the source of funds. Cover-up is the process of hiding facts or misdirecting inquiry to protect wrongdoing. Something is rotten in the state of Denmark. That's all. Thank you.
Thank you. Do we have any additional public comment on item number 4?
Yes, please.
Please proceed.
Thank you, Chair Maddox and Commissioners. My name is Lacey Keys. I'm counsel for the respondent in the stipulation that is under consideration today, and making my comments in capacity as counsel for the foundation. The purpose of my comments is not to reiterate all of the facts in the analysis and the stipulation, but instead to point out that the public record for this meeting and multiple prior meetings contains a number of inaccurate statements of facts and legal analysis. And it would take more than the 3 minutes that I'm allotted to refute all of those inaccuracies, but to highlight a few, the sponsorship definition expressly provides that a funding source of 80% or more qualifies as a sponsor. That's something the commission has looked at closely and is an accurate statement, despite the fact that the volunteer treasurer may have not completed the forms completely accurately. There have been a number of claims made previously and today regarding the source of funds, claiming that they're from the district based on an incomplete understanding of the accounting and fiscal processes of both the foundation and the Los Angeles County Office of Education. The Enforcement Division did issue subpoenas, and the foundation has responded and provided all requested and required documentation to unequivocally disprove that these were district funds. These were foundation funds handled in compliance with all manner of state laws, as well as following recommended accounting procedures that have been issued by the state chancellor's office. There have also been a number of misstatements of minor facts, such as when policies have been adopted and et cetera. Again, I could go into all of these issues, but Chief Brereton, as well as Commission counsel who've worked on the case, are well equipped to respond, given that they've conducted a deep and thorough investigation. The additional reason that I had wanted to make comment is just to highlight again for the Commission that documents provided as part of public comment today and previously do not contain any material that was not previously provided to the Enforcement Division months ago. The issues raised by the comments have been affirmatively raised and addressed by the Foundation in complete cooperation with the Enforcement Division throughout the investigatory and settlement process. All information that was requested has been provided and the outcome of this stipulation remains the same. The Political Reform Act violations that occurred were missed campaign reports. Thank you very much for your time.
Thank you, Ms. Keys. Do we have any additional public comment on item number 4? Hearing and seeing none. I just want to take an opportunity to thank all the commenters who made comments on this item today. I do, however, want to remind my colleagues that when we are approving stipulations on the enforcement calendar, we are sitting in our quasi-judicial capacity, which requires us to only consider the materials in the 4 corners of the stipulation as being presented. And so I know through this process, we've received a number of documents and other things. When we're making our decision today, we really need to stick to the 4 corners of these documents. I would like Chief Brereton to perhaps help explain, for the benefit of the public and frankly even for myself, we see the term non-donor funds, and I think there, in some of the comments we heard, I think it was being used in sort of the lay sense, but there is also a very technical understanding of that term that derives from the statutes within the Political Reform Act. So can you talk to us a little bit about why the money at issue here from the various, and this is referred to on page 7 of the STIP, from Barnes & Noble and Pepsi Company, are considered non-donor funds under the Political Reform Act, which is the law that we are applying here?
Yes, I'd be happy to explain that. So the statute that applies for, that we're referring to, that includes the non-donor funds, that's section 84222, and it governs when a nonprofit organization can become a recipient committee. And there are multiple ways that can happen, most of which concern making receiving money for the purpose of making political contributions or expenditures. That doesn't apply here because the foundation did not receive any money for the purpose of making contributions. They are an entity that does receive money, and that can get confusing. So the other section in the statute that allows a nonprofit to become a recipient committee under our rules says that it will do so if it's made contributions of $50,000 or more. So it's engaging in political activity. The caveat there is if they're using non-donor funds, and that's really where it gets confusing because in the lay sense, they're receiving money. Isn't that a donation? Well, maybe, but under these facts here, the money that they received doesn't qualify as non-donor funds because it was part of a contract, and contracts require consideration. So these vendors were not giving the money to be used by the foundation voluntarily. The regular definition of a donation requires that it be voluntary and there's no consideration. Both of those do not qualify here. So these funds that were part of the district contracts required that money to go to the foundation. So it cannot be considered a donation, and it is non-donor funds for the purposes of the political. So that where it stands then for us is they qualify as a major donor committee under our rules because of how these funds were received and all of the evidence that we have gathered over this investigation. Some was subpoenaed, some was voluntary, but we looked into all of the aspects of how the accounting works and determined that these were the funds that were used. They were available. There was plenty of money there to cover these contributions that were made. So they qualified as a major donor committee. They didn't file their statements timely, and those are the violations that we're bringing before you today.
Thank you. And then one other question for you, Chief Brereton. When this stipulation was originally presented to us, as one of the commenters mentioned, a couple commissioners had concerns about why there weren't individuals named as part of the stipulation. So the commission at that time, we pulled this, we sent it back to your division and asked you to continue the investigation and look into that further. You've now completed that investigation, and my question for you is, are you satisfied that given the facts and the extensive investigation you've done, that it is appropriate not to include an individual in this stipulation?
Yes, we did not find that there were any individuals who had liability under the act. And we have resolved all of the issues involving all of the parties that were named in the various complaints that went along with this. We actually had 3 different cases open. This particular matter involved other respondents then named in this stipulation. Those matters were resolved with no action closure letters. And our other 2 cases as well were resolved with no action closure letters. Our investigation determined that no other entities or individuals who were named in the complaints had liability under the act.
Thank you, Chief Brereton. Do other commissioners have any questions for Chief Brereton on item 4? Commissioner Wood?
I just have a clarifying question. So on the non-donor funds, there's this really key, what I think is a key sentence. At each relevant time, there was a sufficient balance of non-donor funds from those contracts to cover the contributions made to the Yes on E committee. If that hadn't been the case, then it sounds like we would be talking about it in a different way, in the way that some of the public commenters wanted us to talk about it today. Is that correct? Is that what's making this go? Is that they didn't specifically need those funds to make the contributions happen, basically?
Right. If there wasn't
Okay.
sufficient of these non-donor funds, then we'd have to look to see, well, what are the other funds that are in there that were available? We didn't have to get to that point because the non-donor funds covered what was needed for these contributions.
I see. Okay, thanks very much.
All right. And Commissioner Cardenas, I believe you had a question as well, or a comment?
Yeah, just a kind of a point of order. Did we formally take this off consent?
No, we had 2 items on consent. We pulled one of the items, so now we're left with 1 item on consent.
We're talking about item number 4, right?
Correct.
But don't we need to take it off consent in order to deal with it in the way that we are?
Mr. Bainbridge,
What's the question?
turn it over to the expert.
Well, Commissioner Wilson's the real expert on this stuff, but so this is the only item on consent. It's fair to discuss any item that's on consent during this period. So it just happens to be there's nothing else, but it's appropriate to discuss this item as part of the consent calendar.
Actually, Chair Matich, may I, that we also have item number 5, which is on consent, pre-notice default, but that is an item that wouldn't require action.
Chair Matich?
Commissioner Wilson.
Yes. Chief Counsel Bainbridge is correct, but I think for clarity, Commissioner Cardenas's recommendation would provide, I think, a smoother process. So I'm requesting that item 4 be removed from the consent calendar.
Okay, how about this? To avoid any additional confusion, we've already pulled item 3 from consent. I'm moving that we pull item 4 for separate discussion from consent. Do I have a second?
Second.
All right. And so now, for clarity's sake, we just have item 5 on consent. Is everyone in agreement on that? Mr. Bainbridge?
Item 5 doesn't require a vote, so I think technically it's not on consent.
Okay. Well, Ms. Brereton mentioned that she thought it was on consent, so just let us know. Where are we at? The agenda says items 3 and 4 were consent, so is 5 part of consent or not? I just need to know.
No, I do not believe it is.
Okay. So we were discussing item 4. Let's conclude our discussion of item 4 then, if we may. Are there additional questions or comments for Ms. Brereton on item 4? Hearing and seeing none, do we have a motion? I will move approval of item 4. Do I have a second?
Second.
Ms. Linker?
Commissioner Baker,
Aye.
Commissioner Cardenas,
Yes.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Matich.
Aye.
The motion passes.
Thank you. We'll now proceed to item number 3. Commissioner Baker, you requested item 3 for separate consideration. Would you care to make a comment?
Thank you. Yes, I appreciate that. And thank you, Ms. Brereton, for the information I had requested in advance of this meeting was to see the comparable matter that was cited as guidance for the level of the fee. I asked that this be pulled from consideration because as I'm reading it, I look at the factors for what should determine a fine in this case, and I wanted to give guidance that I thought the fine was too low. As I look at the factors all throughout, and they're primarily on page, just for weighing us down here, page 13 and 14, I felt that this was too low. So I had some questions I wanted to ask in the discussion, and then based on those further comment. Chief Brereton, one of the questions goes to Ms. Copeland, who I believe was the treasurer. You mentioned, the stipulation mentions that the other 2 participants did have priors. They were actually priors exactly what is in nature here, intentional concealment. But that Ms. Copeland had priors or prior fines from the commission that were not related to this action. I wondered if you had at your fingertips, roughly what were the areas that they were? Were they late filings? I'd like to know a little bit more about that. She's otherwise not mentioned very much in this, but that was of concern to me.
Thank you. I do not have the specific information for Ms. Copeland's priors at my fingertips, but most of the time, the violations against treasurers do involve campaign reporting issues. So late filing, late reporting, anything else that might be related to campaign statements and getting the disclosure out there.
Okay. And then this is actually helping you do a little bit of math, or helping me do a little bit of math. When I see what our recommended fine in, which was about $25,000, and then the participants are jointly and severally liable, which means they could decide how they're going to do that. If one of them pays it or all 3 of them pays it. But if you were to break that down by just say 2 of them taking responsibility for it, not the treasurer and the other 2, Mr. Fickas and Mr. I think it's Cajon, that breaks it down to about $12,000 each. And as I look at the fees that they received from the work that they did that was paid out by the commission, they'd almost break even. For whatever their fee that they end up paying to us, they're not really digging out of their pocket for what I think was really intentional concealment to deceive the electorate. Am I right on that math, or is that not the case based on the fines and the fees that they obtained through their work as consultants?
Those numbers sound right to me on as far as what's in the stipulation, but I will admit that math is not my strong suit. So
I used rounded out figures, so so I thought that worked out. In the end, as I read this, I did feel that based on the factors that are on page 13 and 14, this is exactly the kind of case that gives meaning to intentional concealment. And in the time that I've been on the commission, we've seen that factor weighed in as a mitigating factor when we looked at stipulations. For example, if there was no intent to conceal, that was often considered a good thing for the other parties in the stipulation. And in here, each one of the factors weighs against the individuals who participated in these facts. I found no mitigating factors at all. In fact, some lack of cooperation, and I don't want to overly characterize. I'd have to go back and see if the stipulation actually says there was not cooperation. I know they did not immediately fix the problem when they were alerted to it, the disclosures. And for my part, I wanted to give guidance that I think we should not adopt the stipulation that it is appropriate for renegotiation of a higher fee. I don't know that I want to tie your hands into what that should be, but I think it's essential and very important in this case. That's the feedback I wanted to give and why I did this. My last question is actually for Mr. Bainbridge. And that is, if there is any, to your knowledge, if there's any criminal conduct from, say, Mr. Fickus, the individual who pays someone else to be the principal officer, but who in fact is one of the two deciding people. If that is a fraud of any kind that carries potential criminal liability.
I'm sorry, I don't know the answer to that question offhand. I haven't looked at this closely enough to know that.
Fair enough. I appreciate that. That is the question I'll leave out in my mind, but my belief is we should not adopt the stipulation and should give guidance to our enforcement team to seek a much higher penalty that's more in line with what I think is the action. I guess I'll add this last point. I did go back and look at the comparables. I also watched the commission's prior work, and I felt the comparable was distinguishable. These are actors who are very experienced in this case. They have very much on point priors of similar concealment. And there was much more cooperation in the comparable case. They cooperated and they didn't have a history of priors. And so I feel it's appropriate that we not feel too tied down from that precedent.
Thank you, Commissioner Baker. And let me just say, I had almost precisely the same reaction that you had when I read this stip. I mean, this checks many of the boxes that the Commission has previously and repeatedly identified as priorities for the harshest penalties that we're able to mete out under our jurisdiction. It's clear, and the stipulation is explicit, that this appears to be an intentional action to evade disclosure and the requirements of the Act. These are sophisticated parties. There were multiple sophisticated parties who, for lack of a better term, conspired in this scheme as presented in the stipulation. They have a history of priors, several of them that do. And I'll tell you, and then to have the penalty be less than 50% of the max here, it just seems incongruent with our priorities. When we say that these are high public harm cases, when we say that we take them seriously, the penalty needs to be congruent with that, and our words need to be given actual effect. And so I appreciate, I know these cases are complicated, they're time intensive, and staff, I don't want this to be a dig at staff at all. You guys do a great job. I just think for the sake of clarity in terms of our expectations as a commission, speaking for myself, and it sounds like Commissioner Baker is of the same mind, this isn't a high enough penalty for this type of conduct. I agree, I don't want to tie your hands and give you a specific amount, but what I would say as part of my last comment here is one of the things that really strikes me is we use these stipulated agreements for comparative value when we're setting future penalties. And one of my biggest concern here is if this doesn't warrant something above 50%, what in the world will? So we need to have that perspective when we're setting the penalties. And so for those reasons, I also have significant concerns, and I'm inclined to reject the stipulation with direction to negotiate a higher penalty. Do other commissioners wish to speak on this matter? Commissioner Cardenas?
Mr. Chair, thank you very much. I'm afraid I find myself in complete alignment with Assemblymember Commissioner Baker and our chair for all of the reasons stated. This particular case, these individuals, I'm not sure how to pronounce, is it Ficus or Ficus and Mr. Chacon. They not only check off a lot of our pre-existing boxes, I believe they are creating some new boxes for us to contemplate in the future. The stipulation as it's been crafted seeks to be adherent to prior direction in similar cases, and I think it does that. To get to one of Commissioner Baker's outstanding points, these two individuals have provide us liberation from prior precedents because they are establishing, I think, to get to the chair's point, a new one. Once again, from the wild, wild west that is politics down here in Los Angeles County, we have something that is thoroughly odorous for a number of reasons. First of all, there's the four corners within which we are ethically and legally required to remain within. But I also want to suggest something related, tangential, which may give us cause to if it moves forward today, I think it needs to move forward with a higher penalty. I'm absolutely convinced of that. But I'm wondering if it needs to move forward today, if it's prudent for it to move forward for the following reason, and that is that these recidivists on an earlier occasion when they were busted, it was, if I believe, if I remember correctly, it was under the guise of PJF Consulting or PJF, whatever their communications or something like that. PJF, I believe, stood for Paul and John Ficus or Fricus or whatever their name is. Paul is one of the two respondents here. His brother John is not a respondent in this case. He is, however, beginning a sentence that was handed down to him by a court of competent jurisdiction up in Salinas just 2 weeks ago of 28 years, 8 months for serial rape. Now, the only reason I even referenced that horrific reality is that there are public record news accounts from up north of individuals suggesting that they had been interviewed by the Federal Bureau of Investigation with respect to John Fricus because some of his victims, he apparently lured them into political campaigns that he was working on under the guise of being able to knock off some of their community credit at school. And these were high school students, some of which he was their field hockey coach. And then there, I want to say there were allegations, but since he's been convicted and sentenced, he drugged them, and then came the violations. But the FBI purportedly, according to some news accounts from up north, was looking at that Fricus's use of campaign cash as it might relate to at least then illegal activity in the area of cannabis sales. It's a wild plot. Here's my point. He was, at least at that time, working with his brother Paul, respondent here. And so my question ultimately is this: are we aware of any investigation which might not be helped were we to move forward with this today? This is thoroughly unseemly. And sometimes when there is this much smoke and it smells this badly, it's even way worse than it appears. Ms. Brereton?
Yes, thank you. I checked with my team on this, and we have not been contacted by any other law enforcement agencies to let us know if there are any investigations. So to our knowledge, we haven't been informed of any. That of course doesn't mean there aren't any out there, but no one has contacted us to express a need for us to pause our investigation or not continue with resolving the matter.
Thank you. I have no further questions at this time.
Commissioner Wilson?
Chief Brereton, there have obviously been a number of major issues raised today. Could you kind of outline, I know you went into detail in your stipulation, what the main conclusions you came to come up with the $25,000 fine?
So in general, we use the factors that are included in Regulation 18361.5, subdivision E. Those were recently updated last fall. So they actually are more robust than they have been previously. So what we do, and I will actually be going through some of this in our enforcement presentation later in our meeting today as well. We go through each of the factors and evaluate the evidence that we have that would weigh in for each of those. So in this stipulation that starts on page 13, where we lay out what the factors are, and then we go through the evidence. So here, we had the public harm was high, because of the nature of not including the name of the sponsor in the committee name. The violators were experienced, so we use that as well. We included penalties from comparable cases, and admittedly, the comparable case that we have here is from several years back. It's it was a different commission makeup, and every commission has different priorities, and but we use them as guidance so that we are moving forward consistently. The intention to conceal, we have discussed that in pretty great detail. Though I would say some of the evidence that we have is mitigating regarding intent to conceal. The contributions that we received from that the committee received were all disclosed timely in their campaign statements and identified the sources. The issue was that those campaign statements didn't also include that the committee was a sponsored committee. But like we did when we reviewed those campaign statements, you can see that there was more contributions from one source than any other. And so that information was available. It just wasn't displayed in the manner that we require. And that's similar to when you talk about whether the violation was deliberate, negligent, or inadvertent. And these types of cases as well, a lot of our evidence comes from witness testimony regarding how we learned about all of that information. So, we don't necessarily have a smoking gun email or a letter that was written. A lot of it comes from when we're talking to folks. The good faith consulting with commission staff, I don't believe that was a factor in this case. I don't recall us having any information that they reached out to the commission. But that is something we take into account as well. Whether it's part of a pattern or the actual individuals and entities have prior violations, We take that into account, and you can see we named several of those prior cases in this stipulation itself. And then whether they voluntarily filed amendments. What that really refers to is, did they go out and file the amendments with when they found out that there was a violation? Sometimes people don't believe that they need to file an amended campaign statement, or they so they won't file the amendment until they've reached a resolution with us. So we do take that into consideration as well.
Okay, thank you.
You're welcome.
Any additional questions for Chief Brereton? Commissioner Baker?
I think mine again is for Mr. Bainbridge. I'm going to rephrase my question regarding criminal activity to, in other instances, we have, in Fountain Valley, for example, we referred the case to the district attorney and the attorney general. And that was also done in the BART matter that was discussed 2 meetings ago, that when we feel like there's been a sufficient violation, that it is appropriate to refer. To your knowledge, is there any activity that you see here that we as a commission have in the past referred to a district attorney or attorney general's office? And if that's not something we know now, if we could have that reported to the commission in the future.
Yeah, I'm not willing to comment on an enforcement case. I think the question should be directed to Ms. Brereton. Sorry, Angela.
Thank you. Got it.
No problem. So typically we will refer matters where we think that there might be criminal activity, potential for criminal activity. Most of the time, campaign reporting type violations are not violations that will rise to that level. I mean, obviously criminal conduct has a higher standard, but the statutes are in the Political Reform Act, the criminal prosecution, most of the, if not all, are misdemeanors if they're taken criminally. And so in the grand scheme of things, our experience is that law enforcement agencies don't always want to take matters of this nature because there's not a lot of bang for their buck, really. But we do have a set standard of cases that we will automatically refer because of the nature of the conduct. For instance, conflicts of interest, 1090. If we see instances that involve campaign contribution laundering, those types of things we do refer, and often it's at the stage when we receive the complaint because those are the allegations that are made. If we discover violations later, which can happen too, then we'll refer at a later time, or at least reach out and say, hey, we've come across this activity. Is it something you would like us to send over to you? So we do have a very cooperative relationship with the local law enforcement agencies. It goes the other way too. Sometimes they have matters that they're investigating, that they determine they can't quite meet their burden, but maybe we'd be interested in pursuing an administrative action.
I appreciate that. I would be interested in knowing if similar patterns like this case, which is not the disclosure part, as well as the one or both of the principals paying someone to be the principal on paper, but ultimately is making all the decisions. If in the past we've ever referred those, and if it is a candidate for doing that here, even if it's a misdemeanor, I leave to law enforcement agencies to determine if they feel it's something within their prosecutorial priorities. But I would be very interested in knowing that at some point. Thank you.
You're welcome.
Any additional questions for Chief Brereton at this time? Hearing And seeing none, we'll take public comment on item number 4. Is there any public comment on item 4? Excuse me, item 3. Hearing and seeing none. Before we proceed to a motion, I just want to remind my colleagues that I appreciate the spirit of Commissioner Cardenas's comments earlier. We do need to make this decision based solely on the 4 corners of the document contained in item number 3, though. So with that reminder, do we have a motion on item number 3?
May I ask another question, Mr. Chair?
Of course, Commissioner Cardenas.
Ms. Brereton, what would a maximum fine look like in this instance?
For this particular violation, the maximum fine is 3 times the amount of the cost of the advertisements, which is $51,699. And I'm not brilliant at math. I'm just that we already calculated that number.
I am not inclined to support the STIP as it stands. I'm not sure that it should be the max, the ballpark figure of which was just, but I think it needs to be north of what is currently in the STIP. It's time to say enough. Ya basta. I live down here in LA County. It stinks. At some point, we've got to draw the line. You're going to do damage to our democratic institutions. You should feel the pain.
Commissioner Wilson.
Inquiry, Chair Madich.
Yes, Commissioner Wilson.
Yeah. Now, just for clarification, Commissioner Baker had raised the question about whether we should put this over. So I defer to you on whether we should address that question first, and then this item would not be voted on today, but the Enforcement Division would further look into the matter and determine whether the penalty of $25,000 is sufficient or whether it should be a higher penalty.
Well, just for the record, I think what we've heard and what we've done in the past is if the commission believes that the penalty is incorrect, and it could be either way, it could be too high, it could be too low, but in either event, when a stipulation is presented to us and that's our concern, I believe typically we reject the stipulation with direction to staff to go back and negotiate either up or down depending on the circumstances of that case. So unless Mr. Bainbridge reminds me of a different process, I think that's the process that we would use here today.
So we'd have to reject it. Okay, thank you.
All right, additional questions or discussion on this item? If not, I'm going to go ahead and move then that we reject the stipulation presented in item number 3 with direction to staff to negotiate, if possible, a penalty that is higher than the one presented in this stipulation.
Second.
Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Madich?
Aye.
The motion passes.
Thank you. All right, we'll proceed now to item number 5. This is a pre-notice of default, as Mr. Bainbridge mentioned earlier. This isn't a matter that we vote on today, but if commissioners have questions or comments for Chief Brereton, now is the time on item number 5. Hearing none, I will just ask Chief Brereton, have we had any contact from Mr. Aguirre, and do we anticipate any contact from him at this point?
Early on, they reached out expressing wanting to negotiate, and they have still not filed any of their statements. So that being one of the conditions of settlement, we have not been able to be successful. So we haven't heard anything more.
All right. Thank you. All right, proceeding then to item number 6. Assignment of hearing to administrative law judge. This is in the matter of Long Beach Families against Measure A. This is an opportunity where enforcement is letting us know that they are about to send a matter to assignment to an ALJ, and if 2 commissioners wish to request that we hear this ourselves, now is our opportunity to convey that to the Enforcement Division. So do commissioners have any questions or comments for Chief Brereton on item number 6. Commissioner Baker?
Thank you. I just had a question about when these opportunities are brought to commission, a little bit of historical knowledge. What has been the practice of the commission, and has there been a prior articulation of these are the circumstances in which we have chosen to hear a matter ourselves, which would probably not be would be a good practice for us to exercise in some instances. But I need a little bit of institutional knowledge, the extent to which you can make it in a succinct way.
Yeah, so we typically, as long as I've been here, the commission has only heard one other case that actually went to the hearing. And that was actually only to determine a matter of law. It was not, there were no factual issues to be determined. Otherwise, the commission did have the Fountain Valley matter previously scheduled to go to a hearing, but it settled. So I am not aware in recent history of a matter going before the commission instead of just the ALJ.
And in the Fountain Valley matter, by the time it came to us, it was, here's the proposed stipulation, which we said we rejected the first matter or draft as I saw it, but it had also been scheduled. This seems a little bit different, or maybe that's the way it presented before I got on the commission, that Fountain Valley, it was not scheduled. The commission was at the same fork in the road and chose one path.
Right. I'll back up. Sorry. So yes, this is the first step. So where we have gotten to here is we have had a finding of probable cause and issued an accusation, and the other party has requested to go to hearing. So then our next step is to find out, we're making our recommendation to the commission that we will take this before an ALJ, but this also gives the commission an opportunity to weigh in if they would like to sit in on the hearing as well. Then the next step after that is then setting the hearing and going through that whole process. So yes, where you came in, all of this had already happened with Fountain Valley.
Thank you.
This actually raises a question in my mind, Chief Brereton, which is within the procedure of setting matters for administrative hearing. If there's a stipulation that's presented to us and we reject it, and you're not able to negotiate a satisfactory stipulation for the commission, and the matter would then proceed to an administrative hearing, at that point, wouldn't that matter come back to us and we would be able to request at that time that we hear the matter ourselves? It wouldn't automatically go to an ALJ, right?
That's correct. It would go through the same regular process.
Okay. All right. So if item 3, for example, if you're not able to successfully negotiate a new stipulation, we would have the ability at a future meeting to direct that we hear that case ourselves.
Yes.
Okay. That's helpful to know. All right. Any further questions for Chief Brereton on item number 6? Hearing none. Thank you, Chief Brereton. All right. Now we will move to item number 7. It's titled the Annual Enforcement Division Review. Chief Brereton and her staff will be presenting to us on staffing, procedures, practices, and statistics. But just for the benefit of other commissioners, this is something that we started after I became chair. We sat down, at the time it was Ms. West was the chief of enforcement. We thought having a regularly scheduled opportunity for the enforcement chief to present operationally how the division works as sort of an educational component to all the commissioners, so we can get a better understanding of enforcement's practices, but also to give the commissioners information on different trends that the enforcement division is seeing, the types of cases that we're seeing, the workload, et cetera. So that can help inform our direction to the enforcement division as well. So that's how we come to have item 7. And Chief Brereton, I will go ahead and turn it over to you.
Sorry, I started talking before I unmuted myself. Thank you. We do have a visual portion of the presentation to go along with this. So thank you very much for agreeing to allow us to make this presentation. We're very excited to tell you about what we do and who our team is and what we have going on. So I'd first like to introduce my management team. Presenting with me today will be Christopher Burton, our Assistant Chief of Enforcement, Tara Stock, our Intake Manager, Jeffrey Kamagaki, our Supervising Special Investigator, and Luz Benetti, our Supervising Management Auditor. As I said, we do have visual aids for you. We will also pause periodically for you to allow for questions or comments during the presentation. Now I have to figure out how I take control over.
You just have to click into the screen and it should allow you to control. There you go.
Wait. Whoops, sorry. Okay. So the mission of the Fair Political Practices Commission is to promote the integrity of state and local government in California through fair, impartial interpretation and enforcement of political campaign, lobbying, and conflict of interest laws. So we have different divisions that handle different aspects of our mission. The legal and education divisions handle advice, training, and education. And our enforcement division handles audits, investigations, and prosecutions. Our enforcement division mission is to fairly, effectively, and efficiently enforce the provisions of the Political Reform Act. So we will have 5 general areas that we will be discussing today. The first section will talk about our enforcement team and who we are and what we do. And the management team will help me to do this part of the presentation. So first, we have 37 employees currently in our enforcement division. 5 are intake political reform consultants or analysts. We have 11 investigators and an investigative assistant. We have 6 auditors and program specialists, 10 attorneys, and 4 support staff. I'm going to have each of the managers talk about their team and what they do. And first up is our intake manager, Tara Stock.
Good morning, Chair Matich and Commissioners. My name is Tara Stock, and I am the intake manager for the Enforcement Division. So I'm going to talk a little bit about what we do in intake. So as Angela mentioned, we have 5 positions in intake, and that includes my position. And then we have 2 political reform consultants, and then we have 2 analysts. One of the analyst positions is currently vacant, but we are working on filling that position. And we rotate on a weekly basis, reviewing all of the complaints and filing officer referrals that come in. We have an electronic complaint system that most of these complaints and referrals come through, and that system automatically populates our internal database. Every once in a while, we do still get some snail mail complaints, and for those support staff, enters those into our internal database. So on our week, when we're on intake, we look at everything that comes in. We look at what the complainant has provided, so the complaint and any evidence or other information provided by the complainant. Sometimes we might need to obtain copies of information that's publicly available, such as campaign statements or statements of economic interest, also known as Form 700. And then, of course, if the subject of the complaint or subjects of the complaint, the respondents, provide responses, of course, we take those into consideration as well. So we look at the entire picture and analyze the information using our statutes and regulations. And then we make a recommendation. We draft up a memo to the Chief of Enforcement, and we make a recommendation as to how we think we should move forward with this particular complaint. So the most common types of recommendations we will make are either to reject the referral or reject the complaint, sorry, because either there's insufficient evidence of a violation of the Political Reform Act, or the allegations may have been disproven once we reach out to the respondent, or it may not even be, the allegations may not even be related to the Political Reform Act. That actually happens a lot. So we get all types of complaints and things from the public. So we would recommend that we reject the complaint in those circumstances, or if we feel like there is sufficient evidence of a potential violation, we may recommend that we open a case and assign an investigator and an attorney to the case. Or if there's already an existing case, we may combine the new complaint into an existing case. Or if we believe that the case will qualify for our streamline program, we will recommend that we open an intake case. So on top of intake staff reviewing all of the complaints and referrals that come in, each of us also have a very large caseload as well that we work on. So most of the streamline cases stay in intake, and we handle those through the resolution. And lucky for me, I have an amazing team. Intake is very fast-paced and very, very busy, and the people that work in intake are amazing. So I'm very lucky, and I feel like all of enforcement is lucky for that. So, let's see. As far as the sources of the cases, as you can see, there are many ways that we can receive information in order to open a case. The complaints, which can be sworn, non-sworn, or anonymous. We receive filing officer referrals, not only from our internal SEI unit, but from city clerks, county clerks, and other state agencies. The most common referrals are campaign and SEI, but we also get from the Secretary of State's office, we will get lobbying referrals as well. And we get some behest of payment referrals. So we have all different types, but campaign and SEI are definitely the most common. And then we have internal audits and franchise tax board audits. And then, of course, news articles or media reports, we might find out of something happening that way. Staff initiated investigations. I think the most common type of that type of investigation would be what we call a spin-off case, where there's an investigation ongoing against a certain respondent or respondents, and it appears that other people have also maybe violated the act, so we'll open separate cases on those. Or even sometimes FEC staff will bring in like a mailer they received post the election that doesn't appear to contain the required disclaimer, so we might open a case on that. The tips, I believe, refers to, we used to get a lot of anonymous phone call tips, but now that people can file anonymous complaints through our electronic complaint system, we get more anonymous complaints. And then we also receive referrals from local and federal law enforcement agencies. Oh, and then on top of all of those, intake staff actually leads a proactive outreach for pre-election statements. So before the primary and general elections, we reach out to all 58 counties and then all cities that have a population of 100,000 or more. And we ask those agencies to refer any candidates who are on the ballot that didn't kindly file their campaign statements to refer those to us so that we can contact those candidates and make sure that they file as soon as possible, and most importantly, before the election, obviously. As far as timeframes go, so with sworn complaints, by law, we have to notify the respondent or respondents within 3 business days of receiving the complaint. And then within 14 days, we have to send a letter to the complainant with a copy to the respondent, letting them know what our intended action will be. Sometimes if we need more time, we might send a need more time letter, but we have to send something within 14 days. But sometimes we will get like requests from either the respondent or the respondent's attorney asking if they can have an extension of time to respond. So in those cases, we might send a need more time letter. For the commission initiated cases, which includes everything but the sworn complaints, there are no legally required deadlines, but we try to send out letters of inquiry where appropriate as soon as possible. We generally allow 14 days for the respondents to respond. If it's a complaint that we receive closer to the election and it's something that's related to the election, we might ask, for a response within 5 days or something like that, like a shorter time frame, but generally it's 14 days. And as far as the public and media being able to find out if we received a complaint, we can disclose that information after 5 days have passed since we notified the respondent. Oh, and we also have on our website, we have it's called a complaint and case information portal. And the information is also available on our website in that portal. It doesn't have a copy of the complaint, but it does have who filed the complaint and the type of allegations and who the complaint was filed against. So that information is available on our website as well. And at this time, I'm happy to take any questions.
Great, thank you, Ms. Stock. Do other commissioners have questions for Ms. Stock based on her portion of the presentation? Well, I had a couple questions for you.
Okay.
The first one is, I'm just curious, the different types of complaints that you receive, anonymous versus sworn. Can you just tell us, are there trends in terms of merit in your determination as somebody in intake? I mean, do you reject more from the anonymous pile or reject more from the, I'm just curious if there's a trend that you can identify.
I would think probably, just because a lot of times the anonymous complaints, and I don't know, I don't have any statistics on this, but I feel like a lot of times the anonymous complaints don't provide any evidence or anything. They just basically say, hey, this person is accepting gifts over the limit, and they don't provide any additional information other than that. And since we don't know who filed it, we can't reach out to get additional information. So yeah, I feel like because we can't contact that person, we likely reject more of the anonymous.
All right. And if, I think we all can appreciate that the Political Reform Act and our regulations can be complicated to understand sometimes. And so when a member of the public who may not be as well steeped in those rules and regulations as we are submits a complaint but gets something wrong. I mean, maybe they're complaining about one thing, but they cite the wrong code section or the wrong reg. Do we, or do you and your team, do you reach out to them and try to understand what the complaint is and help them essentially reform the complaint so that it could be accepted, or what's that process like?
Absolutely, that happens all the time. So we typically, even if they select the wrong violation section or aren't explaining it exactly how we would talk about it under the act, we typically can figure out what they're trying to say. But if not, if we are still a little bit confused as to what they're actually alleging, we will definitely reach out to the person that filed the complaint to get clarification.
That's great. Thank you. Commissioner Baker?
Thank you. Actually, for those cases that you reject, perhaps because they aren't within our jurisdiction, you mentioned that we get a lot of complaints, and sometimes it's just not what the FPPC has jurisdiction over. Maybe it's something related to Bagley-Keene violation or otherwise. Do we point folks in the right direction, or say this is something that would have to be taken up by the Attorney General's office or a different agency?
Yes.
What does that rejection kind of look like?
Yes, that's exactly right. If it's something like that we know that it is under the Attorney General, or it is something the district attorney can help with, we will definitely them in that direction. Sometimes we just don't know, though. Like it's such a different type of complaint that we're just not sure if it actually is a violation, or if it is, who could help them. But yes, like Bagley and Brown Act and Elections Code, we would refer them to SOS. So yeah, for those types that we know who it is that would be able to help them, we will definitely point them in that direction.
Thank you. And then an area that is, I don't know how long we've been doing it, but it's of interest to me, and I think all of us, is the Ad Watch program, where if a member of the public sees an ad that they believe is inappropriate use of funds. I know we recently lived through the Fountain Valley experience, so I'm thinking of that, for example. If a member of Fountain Valley community had received that mailer and thought something's off here, it's a way to notify it. That is the process that you're referring to, inclusive of the Ad Watch program.
Somewhat. Jeffrey Kamagaki will be talking about that more in his presentation, but it is a little bit different because the Ad Watch submittals actually go through an investigator and attorney before they come to intake. So there's already been a little bit of investigation done before it makes it to us, but it is still up to intake to make the recommendation to the enforcement.
Thank you.
Right. Do any other commissioners have questions for Ms. Stock? Commissioner Cardenas?
Thank you, Mr. Chair. Ms. Stock, good morning. I just want to express on behalf of all of us my deep appreciation to you and to your team for the work that you do. We're not able to enforce the Political Reform Act. We're not able to hold people accountable if you and your team are not on the front lines doing the work that you do. Certainly sounds like you all are extremely busy and quite effective. So thank you for your hard work. I just have one kind of general question, if I might, Tara, and that is, if there's anything that, since it's not that often that we get to hang out together, even virtually, is there anything that you would like we 5 commissioners to know? What is that?
I think other than that, we are like extremely busy, and it gets, of course, it depends on, that if it's an election year or not. Election years are absolutely insane. But as Angela will talk about later, it seems as though no matter if it's an election year or not, over the past at least 5 years, complaints and referrals have significantly increased. So we're hoping eventually that maybe we can get more people, because it's really tough, especially around the elections, when we have not only so many complaints coming in, but then we do the proactive pre-election outreach program on top of that. And I think we got about 220 campaign referrals from that proactive outreach. And then I forgot to mention this earlier, but just since September of 2020, we've received over 500 SEI referrals. Yeah, so we just have a lot. And so, yeah, we would just love to have more people, but we all like our job. We know that, we understand that that's the type of position it is. And it's definitely never boring. So, but yeah, just so you know, it's a lot.
Thank you very much. Really appreciate that. So I keep to my 4 colleagues on the commission, I keep suggesting that my time here is numbered. I'm somewhat surprised I'm even here today at all. But let us all keep in mind, we're only as good as our staff qualitatively and quantitatively. Qualitatively, I think we have every reason to believe that we are very lucky. Quantitatively, it sounds like, given the work that our staff has across the board, largely driven by what sounds like an increasingly engaged and perhaps increasingly enraged public. Because, you know, I think a lot of us are getting tired of at least the appearance that too many folks are getting away with too much. The Political Reform Act has really got to mean something again, all due respect. But, you know, it's just a suggestion that you know, one can rest on the quality of one's staff only so long before one really needs to add some more soldiers to the group. That's the suggestion here. But just once again, Tara, to yourself and your staff, thanks very much.
Thank you.
Thank you. Commissioner Wilson?
I want to echo Commissioner Cardenas's comments and also say that, you know, I had the opportunity before the pandemic hit to be able to come into the office there on Q Street with the encouragement of the chair to really see firsthand how the staff operated. And Commissioner Cardenas is absolutely correct that, you know, the staff is hardworking, that engaged. They don't work, you know, 9 to 5. They work more like 9 a.m. to 9 p.m. But, you know, to the extent, you know, we need to identify additional staff. Chair Matich has been very involved. He's a chair who was in the office on a regular, almost daily basis, interacting with the staff. So I think our chair is in an excellent position to be able to assess moving forward additional staff needs that we may be able to put in requests for. So thank you.
Thanks, Commissioner Wilson. Ms. Stock, two things. The first one, I want to recognize that, you know, Commissioner Wilson and I are on the Outreach and Technology Subcommittee. And one of the things that we frequently talk about are ways that we can improve our communications with the public to assist them with understanding the act, et cetera. And it makes me sort of wonder, are there certain recurring challenges that you face in intake in terms of what you're getting with a complaint? You know, they're not attaching the right forms, but is there an opportunity to perhaps do some type of additional educational material on that portion of our website to help people, you know, give them, like, you know, tips for submitting a complaint type of a thing is what I'm thinking, and I'm thinking out loud here, which is always kind of dangerous, but I'm just curious, what is your reaction to that? Do you think that there are particular patterns that you've seen that we could reduce to kind of like frequently asked questions or tips for people who want to submit a complaint?
I find generally, especially with the sworn complaints, that the evidence is there. They attach what they need to attach for the most part. I feel like with the filing officer referrals, we have more issues because we need very specific information. For example, for SEI referrals, we need the notifications that the filing officer sent. We need the most recent copy of the Form 700. And then if it's someone who's filing because they're designated in a conflict of interest code, we need a copy of that code. So we find ourselves reaching out to filing officers all the time to obtain the information that they didn't include. I believe the complaint form or the complaint system does ask for that information. So I'm not sure why it's not included, but I think that's a good idea to at least look at, like, when they're submitting the referral, what it looks like, and maybe we can add information in certain parts of that might be helpful.
Great, I appreciate that. And to the extent that you think that, you know, there's an opportunity to do maybe a training with local folks on how to do that. I know our education outreach folks are always looking at different ideas for trainings, so
Yeah, that's a good idea.
Communicate with them. All right, great. If there's nothing further then for Ms. Stock, thank you again for your work and your team's work. You guys are doing a great job. And
thank you.
I think we have one of your colleagues coming up next year.
Yes, thank you so much. Yes, so Jeffrey Kamagaki is up next, and he will be talking about investigations. Thank you.
Thank you.
All right. Good morning, Chair Matich and commissioners. Thank you for the opportunity again to allow us to present to you an overview of the Enforcement Division. Again, my name is Jeffrey Kamigaki. I'm the Supervising Special Investigator in the Enforcement Division. Currently, I do supervise 10 special investigators and 1 investigative assistant. And when kind of going off of Tara's slides, once a case is officially opened, once intake has made the recommendation to the chief and the chief of enforcement has approved the case to be open for investigation, it is my task to then assign a special investigator to the case to start the investigation. In addition, just as a side note, the case attorney is also assigned to the case once the case is open, but that is at the duty of the Assistant Chief of Enforcement, Chris Burton. So investigations, you always, and this is a point I really want to make, the investigations really take on a image of a team effort, and that's really between the special investigator and the case attorney that are assigned to a specific case. And ultimately, their job is to determine whether there has been a violation committed, or also if a violation has not been committed. Aside from just the investigators and the attorneys be assigned to the case, it should be noted as well that there are sometimes other staff members of the enforcement division can assist with the investigation. Partly because they bring in an expertise, or we just need additional hands on the case and additional help. One such example is the auditors in the enforcement division. There are some times where we do get some very complex campaign reporting type of violations, and sometimes we do have to seek the help of our auditors with the staff to really assist and give kind of more of a forensic auditing eye, if you will, on the case to assist the investigator and also the case attorney on a case. In addition to that, we also can assign the investigative assistant to also assist primarily the special investigators. And a lot of that is more as administrative support for the special investigator during the course of the investigation. In addition, during the course of the investigation, there are some instances I want to make note of is, you know, we do as special investigators, we are, you know, we have the mission to carry out the Political Reform Act and carry out the laws of the Political Reform Act. And there are some times where other law enforcement agencies may have their own case that they have open separate from something that we're looking at. And there are some instances where we do get contacted by other law enforcement agencies, both local and federal, asking for sometimes our assistance and even our expertise on the subject matter that could be related to the Political Reform Act. And oftentimes we do assist our fellow law enforcement agencies anytime they are seeking some additional help or some expertise on the subject matter. And that's a good segue to also mention, on occasion, we in the enforcement division also can carry out joint investigations with other law enforcement agencies. Some good examples would be conducting joint investigations with other local ethics commissions, such as San Francisco Ethics, San Diego Ethics, so on and so forth, and also local county DA's offices as well. So during the course of an investigation, obviously investigators will always be seeking and obtaining records and evidence to determine whether or not a violation has been committed or not. So, so how do we go about as special investigators to obtain those records during the course of the investigation? Well, that goes in, as you can see on the slide, it kind of leads into the FPPC does have subpoena power. So first off, what we look at is special investigators will mainly request from respondents and or witnesses to provide pertinent records for their investigation through a voluntary compliance first. We always seek voluntary compliance first, mainly to see if the person, witness or respondent, is willing to be cooperative during the course of the investigation. However, if respondents or witnesses are not being cooperative in providing records through a voluntary compliance request, the special investigator can then obtain the records through an administrative subpoena. It should be noted, however, there are certain situations where issuing a subpoena first rather than seeking voluntary compliance first is warranted. And there's two situations I want to bring to note here. First off, if we're trying to obtain bank records or business records, oftentimes we will seeking those records through an administrative subpoena. Mainly historically speaking, banks and businesses oftentimes will notify us that their entity does require a subpoena in order to release sensitive records to us. Hence the reason we would then go for a subpoena route first rather than through voluntary compliance. The second situation would be a possible knowledge of the threat of a record destruction by a respondent or a witness. And many times the special investigator will have some reason to believe that the witness or respondent who they are seeking the records from could possibly destroy the records. And we want to preserve those records if we can. Hence the reason we would then try to obtain the records for administrative subpoena. A very good example, generally speaking, is when we're handling money laundering cases. Obviously, those cases carry a high degree of public harm. And oftentimes we have seen, historically speaking, many witnesses or respondents will try and destroy records, mainly communications, such as emails, written notes, letters, text messages, anything of that sort. Those are really key pieces of evidence, the so-called the smoking gun piece of evidence that as investigators, we really want to try and obtain as quickly as possible. So then when you're probably asking, what do we do when we do need to obtain records for a subpoena? Well, what I want to make note of is all subpoenas are prepared in the Enforcement Division. And all subpoenas are first drafted by the special investigator who is on the case, who's seeking certain records. That subpoena is then reviewed by the case attorney who's assigned with the investigator to review that subpoena. And then ultimately the chief of enforcement also gets a chance to review the subpoena before handing it over to the executive director, who then will review and ultimately issue the subpoena. It should be noted though, once it is handed over to the executive director, the executive director will issue the subpoena as long as the records are material to the matter and or to the investigation. And also the executive director reasonably believes that the person has the information we are under their control that we are trying to obtain through the subpoena. All right. So moving on to the next slide, this breaks down sort of kind of our special types of investigations, if you will. In addition to a special investigators and case attorneys, ever-growing caseloads, the Enforcement Division does conduct proactive efforts. And there are several that I want to bring to your attention today. One of them is our proactive laundering, campaign contribution laundering efforts. The proactive effort generally involves the following. It's really a review of local jurisdictions that have historically have contribution limits. We do review campaign statements and additional reports to ultimately narrow down potential laundering activity in those jurisdictions. It could both be local, such as cities and counties. And then also to make note, all of the information that we use during our proactive laundering efforts, all the data we use is actually the information that's publicly available through local filing officers' websites. The second one is conflict of interest. Again, this is not considered a proactive effort. This is grouped into this specific slide because what I wanted to really make clear is, conflict of interest cases can really be labeled under special types of investigations. And the reason I say that is because conflict of interest cases are often complex in nature. extremely time intensive to investigate for the special investigator. And oftentimes these types of cases, they expend a lot of the resources that are available to the Enforcement Division during the entire course of the investigation. So conflict of interest investigations do require the special investigator to ultimately become, if you will, an expert in the subject matter, depending on what the interest is involving during the course of the investigation. And just some very general examples, nothing stating to a specific case or cases, but we've had some instances where special investigators, they actually had to become experts in such things as mineral rights, water irrigation, engineering, real estate development, even farming, and practically the stock market and knowing about stocks. And if you can imagine trying to become an expert in very specific fields that we're not accustomed to day in, day out, you can see where the time intensive type of example of how long it takes to do some of these conflict of interest cases definitely takes shape. So the last thing I want to mention about the conflict of interest cases is, you know, historically, conflict of interest cases do oftentimes carry a high degree of public harm. And we in the Enforcement Division are clearly aware of that. And we do take conflict of interest investigations extremely seriously. As a result, conflict of interest cases are always made as priorities, specifically at the direction of the Commission for the Enforcement Division to investigate. So the third one I want to bring to your attention is AdWatch and the anonymous advertisements proactive effort. Just to give you a little very, very brief background on AdWatch. It originally started back in early 2018. And the idea actually came up was by several special investigators and attorneys in the Enforcement Division, ultimately who felt that, you know, we need a program to be created in order to better assist the Enforcement Division's proactive pre-election efforts, especially during the peak of election seasons. The ultimate goal was to really seek compliance on almost all advertisements to determine if there was any missing proper disclosure prior to the respective election date. And, you know, AdWatch really serves as a tool for the general public. You know, what we felt was a way to get the general public to get involved and also to participate in the process and ultimately looking for any possible advertisements that are out there that are lacking proper disclosure. Ultimately, you know, as you know, California, we are a very, very large state with a very large population, and with only a handful of special investigators, attorneys, support staff. You know, we can't catch every single advertisement that's being ran on the TV or radio or being posted on someone's yard as a form of yard signs or mailers that are being sent out every day. So, you know, ultimately, what we felt was with empowering the public with AdWatch being the tool, the general public could actually be our eyes and ears on the ground in their local communities for the FPPC. And then ultimately having them trying to also alert us, knowing that, hey, they may have found something that they're concerned about with a particular advertisement because it lacks proper disclosure. So AdWatch was also designed to create a more streamlined process for the public as well. And what I mean by that is, now with people with you know, iPhones, they can just go out, they can simply take a picture of a sign they may have just come across during their drive to work or their walk through their neighborhoods, and they came across something that they were concerned about. And they can ultimately send the image of the billboard, the mailer, a door hanger, yard sign, you name it, whatever they saw that they were concerned about, and ultimately submit it through the AdWatch portal without necessarily having to go through the more formal complaint process that we do allow the public to still do, obviously, through the FPPC's website. And it should be noted the AdWatch portal is prominently displayed on our FPPC website for the public to submit any submissions. AdWatch has really come a long way since its inception back in 2018. AdWatch is now obviously accessible through the FPPC website, which we didn't really have before when it first started, but now the public can easily go to our website and again submit any ads that they feel that could be lacking any proper disclosures. AdWatch submissions are commission-initiated complaints, just so everyone's aware of that. AdWatch can actually help expedite how we in an enforcement division can process advertisements that the general public feel are lacking proper disclosure. AdWatch also remains open year-round now. Prior to this, we used to just have AdWatch operational only during kind of the peak seasons during election times, but now we're allowing AdWatch to remain open year-round. However, what I do want to make note of is primarily we still get a majority of any AdWatch submissions during the peak of election periods, when it's sort of a quiet time of the calendar year where there aren't many elections going on. Obviously, we do see a drop in the numbers of submissions. And finally, more recently with AdWatch, we started to now allow the general public to start submitting through the AdWatch portal any campaign-related communications that they feel were at public expense. And those are definitely the violations that we want to also be made aware of. And we felt that through AdWatch, that would be a good platform for the public if they want to reach out to us and have things possibly processed a little more quickly. That is now at their fingertips. So that is all I have for the investigation portion of this presentation. At this time, I just wanted to mention, I'm very proud of my special investigators and the investigative assistant that I supervise day in, day out. I can't ask for a more dedicated and also a very professionally team that, works extremely hard, for the agency, and they definitely have the passion to always be looking out for the general public. And hopefully, in the future, we will, get some support with some additional help. So aside from that, that is all I have. And I'm happy to take any questions that you may have for me.
Thank you, Mr. Kamagaki. Do commissioners have questions? Commissioner Cardenas?
Mr. Chair, thank you. Mr. Kamagaki, good morning. Is it still morning? Good morning, afternoon, evening. Thank you. Thank you to you and your team. Jeffrey, in my tenure, one of the more remarkable evidences of really sophisticated perseverance on the part of your team was the Assemblymember Kanchiamila. I don't know if that's the correct way to pronounce his name. I suppose now he goes by a number in the state's prison system. But once upon a time, he was a city council member. He was an assembly member. He ran for judge, and then he was in charge of elections for an entire county. And your staff determined that he pilfered about $130,000 of campaign funds for an elegant trip through Asia and for his second home in Hawaii. And as I recall, Jeffrey, when we approved that particular stipulation, which I believe was for a fine of $150,000 November 2019, one of the things that also was discussed during that commission meeting was sponsoring legislation that would ask the legislature to, in its wisdom, see fit to raise the penalties for elected officials engaging in that degree of hubris and arrogance. And I'm just wondering, Jeffrey or anybody else, whatever became of that notion that we would seek to have legislation that would raise the stakes for anybody who might want to engage in such hilarity in the future?
I don't know if I'm the appropriate person to answer that question, so I might want to defer this to my Chief of Enforcement, Angela Barrington.
Sorry, it took me a minute to find my mute button. This would be a project that would be handled through our legislative counsel, Lindsay Nakano. So I do not know the current update on that issue.
Do we have any further questions for Mr. Kamagaki at this time? Commissioner Baker?
Thank you. And I don't know if that is one of the bills we were looking at was the that Mr. Assemblymember Lowe might be doing. It was the bill that I'm trying to channel Ms. Nakano a little bit in her absence, but was to have greater penalties potentially for egregious misuse of funds. I do not know if that bill is in the area that Commissioner Cardenas is referring to. So I will leave that in Ms. Nakano's good hands. I do have questions about both destroying of documents and AdWatch. And thank you for a great presentation. I just want to echo Mr. Cardenas' praise for the staff. The quality of and professionalism of the team has been extremely reassuring from day one of my time on the commission. And this is just a reminder of that. You mentioned that in some instances, subpoenas are issued when there's a concern about the potential destruction of documents. I'm kind of curious if, in the civil world of attorneys, there's a litigation hold that as soon as it looks like there's the possibility there's going to be a conflict that could come before a judge, the parties that may have relevant documents or things that are potentially relevant have to stop, say, rewriting their memory tapes of their computers and anything that could destroy relevant documents. I know the chair is mindful of the litigation hold. I wonder if when we send a notice to someone that they are going to be under investigation, that a complaint's been open, if we ask them to preserve all documents related to it, similar to a litigation hold in the civil law practice.
So that's a very good point. I mean, I can't really speak on that because that could be a change in policies or procedures within Enforcement Division. But I want to, you make a point where, I want to say during the course of an investigation, when the investigator sometimes, aside from the political reform consultant, sometimes the investigators are really kind of the first person that's going to make contact with a possible witness or the respondent in such a case. And, oftentimes, we still try to seek voluntary compliance because it shows kind of, if you will, a good faith on the other party's side that, they're willing to cooperate during the course of the investigation and ultimately not stonewall us in obtaining evidence. That's where we do sometimes get, it's kind of, if you will, an investigator's intuition where they're getting the sense where they're not getting the cooperation, they're feeling like they're just getting the runaround. We're not getting any documents we're requesting. Initially, maybe from the political reform consultant who gave us that information saying the person has been very difficult to work with. That is where, depending on the sensitivity of the case, the magnitude, like how large it is, that's where we start to then try to figure out, is it best to just immediately issue an administrative subpoena and issue that subpoena to preserve the records. And that really just kind of, it's a case-by-case basis, again, it goes on the intuition of both the special investigator, the case attorney, the chief of enforcement, in terms of getting a subpoena issued or not. So Yeah, it's kind of a tough question to really give you a straight answer where it's like, yeah, I wish we could just give maybe a little statement saying, hey, please preserve all records. But I want to say, historically speaking, there have been some instances where we have seen people say, oh, I magically lost the records. There's no more email. Text messages this day and age are even more important. So it's real. We're really stuck as special investigators, kind of in a rock and a hard place, if you will, when it comes to those matters. And I can definitely express sometimes the frustrations of my special investigators where, you know, we definitely need the teeth, if you will, that can really instill into witnesses and respondents saying, you know, we mean business and we will obtain those records by any legal means necessary. And that's the message we definitely want to send out to those that we are, you know, ultimately investigating.
Thank you. If you feel that that is a helpful tool to have, I think it's good for the commission to know that. And if we need to undertake a policy process to equip you with that. And I think of it because sometimes destruction of documents is inadvertent and people don't think of, which is, again, my server is regularly backing up memory tapes and they only hold on to it for 2 weeks or otherwise, and sometimes it's not. And so and I don't know how prevalent the problem is, but if that's a tool that we could equip you with, it would be helpful. I'd certainly be open to the commission considering how to do that. And my second questions go to the AdWatch program. And the first one on that is, and I think it's great to have, is how the public is finding out that it exists, what we are doing. And I know we have an outreach committee that may already be looking at those issues. And our chair wrote an op-ed that I came across before coming to the commission, letting people know about the AdWatch program. So I'm wondering, what do we do to inform the public other than having it on our website? And then I have one more after that, and I'll make it quick.
All right. Yeah, so to answer your question about how we let the public know about AdWatch, initially, going back to 2018 when it was initially started, it was kind of a bare bones operation. It was being developed on the fly almost because it was moving so quickly, but it was a program we wanted to be implemented before the election period was coming into in 2018. And our initial efforts were, we reached out to all the local filing officers, both at cities and counties, and we informed them that, try and spread the word out that, we have this new program. It's called AdWatch. And the public can then submit stuff through this AdWatch portal. And again, it was supposed to be a more streamlinable type of process where we could review the ads if it was in compliance or not. And then ultimately, open a case if we definitely saw a violation. And then ultimately try to get compliance prior to the election date. I mean, that's really the main goal of any pre-elections efforts or AdWatch, is to try and get advertisements in compliance. And, oftentimes people realize, it was out of abundance of a mistake that they failed to put the disclosure and they weren't trying to hide who they were. And we reach out to that committee and they make the proper corrections prior to the election. And then other times, obviously, we do have some cases where they were people were trying to purposely conceal their identity and not disclose, any proper disclosure on an advertisement. But more recently, what we tried to do is we tried to reach out again to the public through our communications director, J.Y. Ranga, who does an amazing job letting media outlets know and keep reminding people, hey, AdWatch, it's still around, it's open year round, and we're willing to take any submissions that the general public wants to submit to us. And then also, it's just, if you will, the political community, if you will, kind of speaking just generally about the filing officers, it's a close-knit community, in my opinion. And we have a good working relationship with various city clerks and county clerks throughout the state. And again, we always try to still reach out to them because again, they're, our point of contact for their local communities. And we do hope that, you know, they are spreading the word and keep reminding people about AdWatch. And then again, I think we've also done some social media type of kind of promotion for AdWatch, especially when it was posted on our website, where people can now, you know, use it on our website and submit the any ads that they wish through the AdWatch portal. And we hope it just kind of generates some word of mouth too. You know, people are telling others, you know, again, it's without kind of what I would call a promotional budget that we can work with, where we can run ads or something, you know, on TV or, you know, the radio about AdWatch. You know, we're very limited on what we are able to do, but I think we're making inroads throughout the state. And I personally have seen an increase in AdWatch submissions ever since the inception in 2018. So I've been very pleased with how it's going. And I think it's going to keep growing for the years to come, in my honest opinion.
Thank you.
Mhm.
Yeah, that's wonderful. And of course, the public would have to know it exists, and then what would qualify as a problem. They may not know about disclosures or the misuse of public funds, but that could all be part of the messaging. So thank you very much.
And I'm sorry, Commissioner Baker, you made a good point just now. What I want to also mention is we tried on the website, we've also tried to, we're trying to update AdWatch every time, because we always see, you know, a possible flaw or something we can improve on. You know, AdWatch is a growing thing that can always be improved on. And one thing we definitely did recently is we started to list certain items that wouldn't fall under AdWatch. So people, the general public, would then be aware, like, oh, I have this image of a sign or something, and then they can look at, there's kind of a list of things that wouldn't qualify for a violation under the Political Reform Act, especially for an advertisement. And it kind of just gives the general public just kind of a quick little, aha, I got it. This doesn't look like it's going to be a violation. I won't submit. But again, I never want to discourage anyone from not submitting anything. You know, if they're unsure, still submit it. You know, we will review it.
Great. Thank you very much, Mr. Kamagaki. That was informative. And again, echoing what other commissioners have said, you and your staff are doing a fantastic job for us. So appreciate it. At this time, we have gone a little bit over 2 hours. And so unless the other commissioners had additional questions for Mr. Kamagaki at this time, I'd call for a 15, well, we'll just say we'll take a break until 12:30 and then reconvene at 12:30. Without objection, see you.
Sorry, Chair Madich, I'm sorry. I know everyone needs to take a break.
I have it on my screen, so I didn't mean to do that.
Oh, you couldn't see me? Oh, how funny. I was like, hi. I also really appreciate these whole sets of presentations. I am very hungry for more data. I want to know how many AdWatch complaints there have been. I want to know how many you followed up on and that sort of thing. And I know we're so resource constrained on the enforcement side, or at least that's a message I'm really receiving today. But it would be nice to maybe talk offline about that. Well, I don't know if, I guess we can, offline about how maybe me and my students could help support some data gathering for this sort of thing, just to kind of help the commission at least be able to track what we're doing if we're not currently able to on our current, you know, resources. Because it, if AdWatch is useful and good, this is the kind of policy that can really diffuse around the country in a way that would actually help the public just be more informed about their local and state politics in an age where local journalism is really on the decline. And so I just want to reinforce that I think it's a really important program that we're running here. And I would really, really love to have more data on how successful it is, because it seems like it's successful, but what do I know?
Yeah, thank you, Commissioner Wood, for those comments. And yes, that would be definitely something that I can provide, probably through my Chief of Enforcement, Angela Barrington, and something we can discuss in the future if you so do wish. And again, I have prepared reports in the past for AdWatch numbers. So again, when you feel that you want to reach out to us, I will be more than happy to discuss with you and of course with my Chief of Enforcement, Barrington.
That's great. Yeah, if it's successful, it's something we should really brag about, you know? So, thanks, guys.
Thank you.
Great. Thank you very much again. So we're going to go ahead and take a break, and we will reconvene at 12:30. Thanks, guys. Right. All right, we're going to go ahead and reconvene at this time. It's 12:31, and this is the regular meeting of the California Fair Political Practices Commission. We are in the midst of item number 7, which is our Enforcement Division review. So, Chief Brereton, who's up next?
Good afternoon. Thank you. Oh, wait, I'll wait till our visuals come back up.
And while that's happening, I just want to encourage you and your team. I know we still have a ways to go in your presentation. If there's any way we could wrap that up by 1:15 at the latest, so that we can continue on, because we do have another couple substantive items on our agenda today.
Got it. All right. Okay, next up today is our Supervising Management Auditor, Luz Benetti.
Good afternoon, Chair Matich and Commissioners. I'm Luz Benetti, Supervising Management Auditor. As mentioned previously, we have 6 auditors. Can you hear me okay?
Yes.
Okay, got it. So we have 6 auditors, 2 program specialists who have been conducting PRA audits and investigations for about 5 years or more. We have 2 staff services management auditors who have been conducting PRA audits for about 1.5 years or less. We have 1 retired annuitant who is obviously not a full-time employee, and myself. Okay. The FPPC auditors conduct audits per the PRA of controller, Board of Equalization, CalPERS candidates, and their committees. In addition, per contracts, we perform audits of local candidates and committees as well. So we've had a continuing, we continually sign contracts, for example, with San Bernardino to conduct audits of their county candidates and committees. In addition, we may also conduct discretionary audits. This includes campaign and lobbying audits. Okay, we'll go on to the next, okay. In addition to audits, the auditors also conduct complicated campaign investigations and assist other staff with complex campaign investigations as well. We also prepare and conduct the public drawings to select the statewide candidates, legislative districts, lobbyists, local jurisdictions, superior court offices, and general purpose committees for audit. We also act as a liaison with other agencies and assist with proposed laws and regulations as well. And I wanted to also note that the audit reports are a public document. They are available at the Secretary of State or at the local filing officer for the local filers. For the public draws, the upcoming draws are announced on our website. The results are posted usually the same day or by the next day, and the details regarding who and why a filer is subject to audit is also posted on our website. And something else I'd like to note is when we contract with a local jurisdiction, we provide plenty of information, helpful information on our website, in addition to lists of the records they need to maintain and provide for audit, their contribution limits, and lots of links to other helpful things as well. So I also am very proud of our staff. We work really, really hard. And some of the big cases that you mentioned, I think Cancelilla was mentioned, that was a program specialist. The money laundering program was spearheaded by a program specialist years ago and developed all the training material, trained the auditors at FTB how to detect money laundering, and also trained the staff, including investigators and auditors that had less experience at the FPPC. That was years ago. that person's no longer with us. He's since retired. The dark money big case was also a program specialist. So it's really nice if we do have time to work on investigations or other more proactive workloads. It's very helpful for the whole program when we get involved. We also helped a lot to in drafting the subpoenas to make them a little bit better and tighter. When I came over to the FPPC, every time I worked on a subpoena, the prior chief of investigator would say, we need all those copies. We need every copy because we need to make them a template. So for everybody to use. So I just wanted to stress that our jobs are very important. And I apologize. I have a new kitty, and if you hear him, I do apologize. Let's see.
Glad to know it's not just me now.
No, good timing for my kitty. I'm so sorry.
I have enough voices in my head, you know what I mean?
So basically, at this point, if you have any other questions, I am happy to answer your questions.
Thank you very much, Ms. Benetti. And I'm glad actually that you pointed out for the public's benefit and for our benefit, the role that your division played in the dark money case, of course, from several years ago that got so much attention, the Cancy Amelia case and the money laundering program, because really, you know, when those things are talked about publicly, I don't know that your division gets the credit it really deserves. Really are the backbone and the reason that we have those cases, along with our investigators and our attorneys. So thank you again for all of your hard work. Commissioners have particular questions or comments for Ms. Benetti? Commissioner Baker?
Thank you. I had a question about timing. I'm very curious, and this may be coming up later, and I'm happy to receive the information offline. Like, what's the average amount of time it takes to do some of the audits of statewide candidates, if it takes a long time or if short, and what tools, if you had your druthers, in order to either do more work that you feel like you're not able to do because of constraints or look into issues you'd like to, what would you like to have that you'd like us to be aware of?
Well, one of the things I've had the opportunity to be conducting the political reform audits with the Franchise Tax Board. I started in '92, came over with the commission in 1999. So what I have seen is the campaigns grow tremendously, money-wise, both the campaign and the, hold on a second. Both the campaign and the lobbyist have grown quite a bit as far as money they raised and spend. In addition to that, I've seen the laws require more reporting and disclosure and record keeping. For example, Prop 34 brought in contribution limits, extended the 24-hour period for filing reports. And there's now controlled candidates will have a number of committees as well. This wasn't typical in the old days. They might have 5 controlled committees, 2 or 3 statewide, a couple of locals, and then they're transferring funds among these committees. So the audits have become more complex. But yeah, I haven't seen the staff or the resources increase accordingly. And also, I wanted to note something else is the thresholds under 90,001 when somebody's subject to audit have not changed. There has been proposals in the past and they haven't gone anywhere that I'm aware of. So for example, to be audited for, if you run for governor, for example, if you raise or spend $25,000, all those candidates are subject to audit. The ones that don't will be randomly selected. That threshold has not moved since I'm aware. And also the other percentages to select other entities for audit, whether, the general purpose, that threshold hasn't moved. It's still $10,000 or more than $10,000 for that one. So if you look at 90,001, those thresholds have not moved, but I have not seen the staff and resources increase accordingly. So that's just my opinion and my observation.
Thank you. Well, that's what I was
I don't know if I
looking for,
answered your
so.
question. Okay.
And the first one was related to if there's a way to supplement this report with data on what's the average amount of time it takes to do some of these audits. Having been a member who had the luck of not 1, but 2 random draws in a row, at which nothing problematic was found, but they do take a while. So I've been on the receiving end of it. I'm curious what type of time frame there is. And again, if this is something that in the interest of time can be provided supplementary, I'm happy to receive it that way.
Well, it depends, but it can range to, it depends on the dollar amount and also how cooperative the filers are. So it can be anywhere from 60 hours, 200 hours in that range. Again, it depends on the filer. Some of the local filers may not have a lot of activity, but they're not as sophisticated. So it's harder to maybe work with them and get to get their records. But yet another bigger committee would have a professional treasurer and provide all the information online. So it's much easier. So it's not just based on the dollar amount. It's just a lot of other things. So it can range, but I'm happy to provide additional information later on if you would like for that.
Thank you.
Great, thank you. Any additional questions for Ms. Benetti at this time? Commissioner Wood?
So I've written a little bit about audits in my academic career. And one hypothesis we've had, which I would be interested to hear your take on, not for my own edification, but because I believe that these audits actually could serve the public in really important ways, is whether you see, so I forget how long you said you've been with the commission, but whether you guys have been observing that compliance is actually either getting better or has kind of reached a kind of high equilibrium and is kind of hanging out there. The theory that we've had about these things is that it will select for people who are more willing to undergo the audit, more willing to kind of keep clean books, just by knowing there's a risk of being audited out there. And so because of that, I would hope that our elected officials would be willing to kind of take on this risk and allow the program to continue, right? Like, I hate to kind of open the audit box for too much scrutiny by the elected officials, because I know it's kind of a pain for them, but I also think, at least if theory serves, at the end of the day, that the public would actually be getting kind of a higher quality in terms of compliance from their candidates. Or do you guys see over time any change in the level of compliance or the number of violations that you see, or the severity of those violations?
Well, one of the things I've always said is knowing that you can be audited is a deterrent already.
Yeah, from running, right? If you're
from
kind of a marginal type.
Well, hopefully you'd want to comply, if you know you could possibly be audited. One of the things I think I've seen, again, I've started doing these audits in 1992 and then came to the commission in 99. One of the things I have seen is the resources, because there's such an increase now in what we have to review because of the laws have changed and the dollars have really increased. One of the things I've seen is if all the audits cannot be conducted, for example, we have managed to do it, but also the Franchise Tax Board has a large workload, and if they're not able to conduct all the audits, and so then what kind of a deterrent is that? So knowing you can be audited and that the audits are going to be done is a good deterrent, and we have been able to do that at the FPPC. Of course, if we continue to increase more workload or the campaigns continue to increase, we need to increase our staff as well. Like I mentioned, in the old days, one candidate would be in office for a number of years and have one committee, and they could redesignate. There was no limits. Now you see a candidate might have 5 committees, 2 or 3 statewide, which easily meet the 25,000. They might raise $1 million or $2 million into each committee. And in addition to that, have 2 locals, and then they're transferring funds around. So they've become a little more complicated, but knowing you're going to be audited is a good deterrent.
Okay.
So yes, and I think there's more information online for people and knowing that they can be audited, and there's more information for them to see. So they have become a little more sophisticated, and there are professional treasurers out there as well that are tapped even by the locals. So that's good. So it's hard to answer that question. I don't know if I've answered that well or not.
Well, it's like the complexity of all of this kind of becomes a jobs program for the professional treasurers too, right? But that's not really what the purpose is, right? So the purpose is to kind of bring people into compliance on the front end because their risk of audit is, non-zero or whatever, as we would say in the ivory tower. Anyway, thank you for all your work.
One thing I'd like to point out in regards to audits, when I was initially trained, and I've always passed on this message and I like it, audits are also considered an education for the public. So when I run into an audit, somebody who's not as sophisticated, they don't have professional treasurers and all the attorneys, but they're trying to comply. I always refer them to all the resources out there and how to do the searches very easily. And to make sure they call. And I said, we have the professional treasurers and the professional attorneys call us all the time. You should do that. That's what we're here for. And they're just really relieved to hear that. And so then next time, they will surely do that. They don't necessarily have to have a professional treasurer, but at least they feel more confident moving forward on that the resources are here to help them.
Thank you for that. And I think that's a good point that you just made, Ms. Benetti, because it goes to, I think Commissioner Wood is right. I think the prospect of an audit on the front end is a deterrent and increases, at least in theory, increases the prospect of compliance in that way. But also on the back end, after having gone through the audit and understanding those audit findings, that serves an educational purpose as well, so to increase compliance in the future as people get more experienced. So I think it's really a valuable tool for gaining compliance, among other things. So
definitely.
Thank you, Ms. Benetti. Commissioner Wilson?
I don't want to drag this on necessarily, Chair Matich, but Ms. Benetti, thank you for your presentation. I have a quick question. In the situation where you reference professional treasurers, without referencing any specific news reports, where you see a pattern with a specific professional treasurer, has that ever resulted in other candidates or office holders being audited based on a pattern that ties back to a specific professional treasurer?
Yes, when we see a pattern with a specific professional treasurer, we definitely look deeper and further. So yes, that could add additional audits.
Okay.
Yeah.
Okay, thank you.
Great. Thank you, Ms. Benetti. Appreciate your presentation. All right, Chief Brereton, who from your team is up next?
Next, we have our Assistant Chief of Enforcement, Chris Burton.
Good afternoon, Chair Matich and Commissioners. My name is Chris Burton. I am the Assistant Chief of Enforcement. The next portion of our presentation will walk you through the various paths that a case can take once it's handed off to the attorney, following an investigation and any necessary audits. And I'll try to be as quick as possible so we can keep with our schedule. So the first slide here walks you through the different ways in which a case can resolve. The first one is a no action closure letter. If following an investigation, it is determined that there's insufficient evidence to establish that a violation occurred or the allegation has been disproven, the Enforcement Division will go ahead and issue a no action closure letter. These letters typically include a brief summary of the allegations and some level of explanation as to the enforcement's findings. An advisory letter, these are not as common, but an advisory letter will be issued in the scenario where a case closure is appropriate, but enforcement believes that it would be helpful to educate the respondent about the requirements of the Act in order to help them avoid any future violations going forward. Warning letters do not carry monetary fines and are issued for violations which carry the lowest level of public harm. When considering whether or not a warning letter would be appropriate, the Enforcement Division relies on the streamlined regulations and the factors that are in those regulations. The stipulations, these are negotiated settlements between enforcement and the respondents, and they may come in the form of either a mainline stipulation or a streamlined stipulation. The next couple slides will go into a little more detail about stipulations. The default judgments, these are presented to the Commission if the respondent does not participate in the administrative process or settlement. They typically follow service of an accusation where the respondent does not file a notice of defense. And the default process is now a two-step. The default is first pre-noticed on a Commission's agenda, such as the item that we had earlier. And then this is followed by presentation of the actual default itself at a subsequent meeting. Decision from an administrative hearing. If a case does ultimately go to hearing, the hearing results in a decision, which is issued either by an administrative law judge or the Commission, if the Commission chooses to hear the case. If the decision is rendered by an administrative law judge, then the decision always comes back to the Commission for their approval before it's final. And then finally, the Enforcement Division does have authority to initiate civil action in some situations. At this point, it is rare that we would take advantage of that. The most common scenario where we might invoke that would be if we need, if we're seeking injunctive relief, such as perhaps a current office holder who continuously fails to file their campaign statements. They're still in office. The public harm there perhaps could warrant that we would file a civil action seeking that injunction. So as previously mentioned, many of our cases do end with a stipulated settlement between enforcement and respondents. Enforcement typically proposes a settlement early on in the case prior to the issuance of a probable cause report, although settlement can occur at any time during the life of a case. Any stipulation will include an admission of violations by the respondents, an agreement on relevant facts, and some sort of monetary fine. In addition, the respondents are always required to publicly disclose any previously undisclosed information. The best example is if a committee, let's say, failed to report certain information on their campaign statements, they're always required to go back and file corrective amendments with the filing officer disclosing that information. So as previously mentioned, enforcement proposes two different types of stipulations, the mainline and the streamline. The mainline stipulation has more meat to it. It includes a full factual narrative, the applicable law, and a full analysis of the factors to be considered by the commission. They're typically presented where the case does not qualify for the streamlined settlement program under the regulations. Mainlines usually carry higher penalties as well. All mainline stipulations appear as individual agenda items on the commission's agenda and must be approved by the commission. As for streamlined stipulations, these are presented in those cases that meet the commission-approved criteria that's found in the regulations, which were recently updated, and these typically carry lower penalties. The stipulations themselves are form documents. They contain basic information related to the charged violations. And the streamlined stipulations are different in that they're approved by the Chief of Enforcement, but they are reported to the Commission every month on the agenda, and they're contained in the executive staff report. Finally, if a case does not resolve via settlement, the case proceeds through the probable cause and administrative hearing process. We have this helpful flow chart. I'm not going to walk through every single box that you see there, but just to summarize, the administrative process always begins with the service of a report in support of a finding of probable cause, which we typically refer to as the PC report. Once it's served, the respondents have a few different ways in which they can respond to that report. One of which is they can request that a probable cause conference be held. And that is held before a hearing officer, which is typically an attorney from the legal division. Once probable cause is found, the enforcement division will issue and serve an accusation. This is the official charging document in the case. After the accusation is served, the respondents have 15 days within which to file a notice of defense if they so choose. And that's the document in which they would request an administrative hearing. If a notice of defense is not filed, then enforcement proceeds through the default process, which we discussed earlier. If the notice of defense is submitted, then the enforcement division notifies the commission of the pending administrative hearing, as you saw in an earlier agenda item today, and then proceeds to schedule that hearing with the Office of Administrative Hearings through a document called a request to set. Our hearings typically can last anywhere from as brief as a half day up to a week and perhaps even more. And those hearings take place in 4 different locations around the state. And typically, administrative hearings tend to mirror a civil trial in terms of their structure. Following the conclusion of the hearing, a decision is issued by either the administrative law judge or the commission, and then that's the end of the case. And that is the end of my portion of the presentation. I'd be happy to answer any questions that you have.
Thank you, Mr. Burton. Do commissioners have any questions or comments for Mr. Burton? Hearing and seeing none, I would just, for the record, note that Mr. Burton mentioned earlier how our agency has civil enforcement authority. It's rarely used. What he didn't mention is Mr. Burton was the lead attorney on a case during the last election cycle, if memory serves, where we had precisely the situation he described. A public official was not filing their reports, and Mr. Burton successfully obtained an injunction to require those to be filed so that the electorate had the benefit of those before voting. So good job, Mr. Burton. Good job to your staff, and appreciate your presentation, sir.
Thank you. Appreciate your comments.
Yep. All right, Chief Brereton, who's next?
It's back to me. We do also have support staff in the enforcement division, and they support us in all facets of our enforcement duties. One of which is responding to all of our Public Records Act requests. They work with the attorney who's assigned on rotation to respond to those. They also help us with our database and running reports and updating our website pages. They provide paralegal support, intake and ad watch support. When we go to hearing, they help with preparing the exhibits that are necessary. As well as general scheduling, mail, office support. That last being particularly needed during COVID when we're not all in the office. So they come in periodically and help us make sure that that all keeps running. Does anyone have any questions or comments about support staff? All right, I'll keep going then. Our next section, we'll talk about enforcement trends. In general, we see complaints increase in election years, but recently we've noticed that referrals are not slowing down. That had been the pattern for a while. So what that means for us, though, is that our workload is increasing over time. This slide shows how it's been increasing. The green represents referrals and the blue represents complaints. We have full year data through 2020. Referrals do include everything from campaign, SEI, lobbying, annual fees, gifts, behested payments, and biennial notices. Biennial notices refer to conflict of interest code amendments. We believe that the rise in referrals is due to better education of filing officers through our education division, as well as from our pre-election efforts, reaching out to filing officers. We're making them more aware of ways that they can help get people to file, which is, referring them to us. So we've been getting more. And just for your curiosity, of the complaints, of the cases that are on the agenda for today, both the streamline and the mainline cases, about half and half were complaints and referrals as the source. So I'll talk briefly about our complaints received comparing 2019 to 2020. You can see the number nearly doubled for the election year from the previous year. We do still have this section here called intake review. What that means is we haven't figured out yet what we're going to do with those complaints. Either we're waiting for more information before making a determination, or we just haven't been able to make a determination yet. And it's since it's often they're not sworn complaints, and so they since they don't have as quick of a time frame, those can sit on the back burner for a bit. Mostly their campaign from 2020 because of the election, we had so many complaints coming in right before the election. We're still digging through those and trying to get those wrapped up. Oh, there's supposed to be more information on this slide, but I'll just describe it for you instead. Sorry about that. This was a comparison of referrals between 2019 and 2020. What is notable here is actually here on this part. The little orange part means that we still have some referrals from 2019 that are in process. We have a considerably larger number of referrals in process for 2020. And as Tara was saying earlier, we received a large number of SEI referrals at the end of 2020. And so they have backed us up a little bit in that respect. But we are already starting to process those. The ones from 2019 that are still in review are due to primarily behested payment referrals. We had already begun the process of wanting to add those into our Streamline program. And so they've been on hold until we had the new Streamline program developed so that we can process them in an efficient manner. So now that we have those underway, we've already begun to get those taken care of. Just a reminder too, our intake staff does carry caseloads, so they don't just process our referrals and our complaints. They also process cases that are handled through the Streamline program under my supervision. So sometimes it's difficult to balance all of those different roles at the same time, and so the things have to be prioritized accordingly. I'd also just like to remind you that sometimes non-filer referrals seem basic when they come in, and then as we look into it a little further, they might reveal some more serious violations. For instance, sometimes statement of economic interest non-filers can lead to conflicts of interest violations as we do a little more investigating. So does anyone have any questions about our enforcement trends?
I had one quick question for you, Angela, on the referrals, the 2020 referrals, 1,517 referrals. What percentage of those are internal referrals versus referrals from outside filing officers?
At this moment, I do not have that data, but I believe I can get it through our database. So I will ask my staff to look into that and get that information to you.
Okay, thank you.
Okay, so the next section we'll talk about is resource allocation. So basically, this is the types of cases that have been opened in 2018, 2019, and 2020. And you'll see here, this is a pretty typical pattern. Most of our cases are campaign and SEI, statement of economic interest. So that's the lion's share of our work. Campaign, that category includes late filing, late reporting, contribution limits, campaign contribution laundering, and annual fees. The category that's listed as other, advertisements, lobbying, conflict of interest, gift and honorarium, behested payments, and revolving door. Also typical for 2018, 2019, the campaign was heavier in 2018 than 2019, and SEI was heavier in 2019. But 2020 showed more of a balance. So that was unusual. This is a little more specific about the campaign cases that we opened, the types of violations. So the campaign non-filer is our largest group, followed by mostly either non-reporter or annual fees. The other category that's on here includes record keeping, misuse of campaign funds, cash in-kind contributions, and bank account violations. And I should explain how we determine what the case violation type is. Our database requires us to include one violation type per case. So we have developed a hierarchy of violation types based on direction from the commission as to what types of violations take priority. And so if there's a case that has multiple violations alleged, we will use that list to determine the one that is highest on it, and that is the violation type that we attribute to that case at the time that it's opened. This slide details how long cases are open per violation type. The days open are determined from the date that the case is opened in our database to the date that the case is closed in our database. You'll see some of the cases in general take longer than others, and there are lots of reasons for delays in cases while we are investigating. COVID and working from home has been a big obstacle for investigations. It has gotten somewhat better, but filing officers in particular, some are open, some are not, some are open part-time. And so, getting information from there or having people file has been a challenge. Sometimes we have uncooperative witnesses, which can lead to service problems, evading service, and production delays. Sometimes there are disagreements regarding what types of documents need to be provided to us. And so then we have to negotiate with the respondents about that. Sometimes there's a change in their representation. They get a new attorney and that new attorney needs to come up to speed. If there are multiple parties and multiple allegations, that can make it more complicated for investigating and resolving. When there are audits pending, if we know about them, we typically will hold on any resolution until the audit is complete so that we have a complete picture of the activity. And as we've mentioned previously, our caseloads are pretty high. So, we can only get to cases as we can get to them. Our managers carry caseloads as well. So, some of our attorneys right now have caseloads that are over 90 cases, which is really high for an attorney, particularly if the cases are complicated. But even though we have all of these delays and we have these caseload issues, we are working diligently to find ways to make our resolution of cases more efficient. The biggest being our recent addition of the Streamline, expansion of our Streamline programs. The idea there being that we will be able to more efficiently resolve more cases so that we can then focus on the more egregious ones. We're hoping to see an increase in the Streamline resolutions as the year progresses. We just now have started using the new rules because they went into effect last month. And there are several on the executive staff report for this month that use the new regulations. So we're already starting to see the benefits. Before I continue, does anyone have any questions about this section, about cases and pendency?
Well, Angela, just very briefly, the campaign bank account cases, the median time, and this is from 2016 to 2020, so it's not just during COVID times, it's in the before times too. So I'm just curious, can you briefly tell us what in particular about those types of cases is causing them to take so long to resolve?
Campaign bank account cases are tricky because there are in order to find out what's not going into the bank account, we have to figure out where that information is. So sometimes there isn't any, it's cash, but sometimes it's a different bank account, which can then lead to other delays, more subpoenaed records. It means that we need to more thoroughly investigate the actual campaign records themselves as well to determine, well, you have this record here, why isn't it matching up in the bank account? So there's a lot of cross-checking and double-checking of multiple different areas and records. It's also usually that, campaign bank account here is listed on its own. That is rarely the only violation that is included in a case that involves one bank account issues. So those other violations can also lead to some of the delay. For instance, cash contributions and expenditures make it very hard for us to, figure out where the money went and what it's being used for, who it came from. So those are some of the reasons that cause an extra delay in those types of cases.
Great, thank you for that.
I have a quick question, if that's okay.
Yes, please.
Just, do we have enforcement priorities posted anywhere? Do you set enforcement priorities? Do they change year to year? Like, how do you decide what everybody has 90 cases. So how do you decide which 5 to work on this month or this week or whatever,
Most of the time, we do not have them posted anywhere other than discussions at commission meetings, for instance, about how they want us to, how we are supposed to be prioritizing which types of violations to pursue. But we also, so we use that guidance. In conjunction with the age of the case, sometimes there's a statute of limitations issue coming up, so that will push a case to the forefront. Sometimes with pre-election type efforts, those are prioritized because we want the disclosure before the election occurs. So those jump to the top of the list. So there are a lot of different factors that weigh in for an attorney and investigator and intake staff to decide, well, I need to prioritize this one this week. So we use direction from the commission as well as timing and the types of violations that are there to determine what we prioritize. And it's changing all the time, at least with the timing aspects, because different cases have different timelines. And so we're constantly adjusting to make sure that we're keeping on top of them.
Okay. I'm like shocked at the size of this backlog and like really feeling for you guys. And it sounds like so much of it's about resources, but within the budget constraint, there's just a bunch of allocation that goes on. So it sounds to me like there are some cases, like if somebody has lost and won't run again and the violation was pretty small, you just may not get to that for a while. But if somebody, if the election's almost here and the person is already an incumbent or it's a certain type of violation that's really sensitive, then that one is going to get prioritized, that sort of thing. So you're just always kind of moving things around. Is that right? I mean,
yes. Yeah, there's a lot of moving pieces for sure. And like I was saying, the new expanded streamline program should help. I mean, that is the goal of that program, is to help us to be able to move those simpler, less complicated, less public harm type cases more quickly, so that then we don't have as many cases waiting for us to act on them.
Yeah. Okay. Just like in terms of deterrence, right? Like in terms of deterring bad behavior, like you want the enforcement to happen
now.
Yeah, in this lifetime, right?
Right.
Now, in this decade, whatever, right? So I appreciate all that you're juggling.
All right, additional questions, Commissioner Baker?
If we were to think, which this just may be a tough thing to predict, I'm also so sorry to see the backlog, but if we were to predict when we might start to see results from the 2 tiers of streamlining, what would be your best guess of when we might see that? Would that be on in another quarter, hopefully sometime this year, based on what you see here? What would be when would we start to see hope for that?
I would think we'll start to see some significant increase by August, September timeframe.
Thank you. I appreciate that you're providing this information and that this is a report to us on a semi-regular basis. If it does not keep you from doing the work, if there's a way for us as a commission to see an update on a quarterly basis as we're watching of this slide right here, and maybe others if commissioners are interested, as we're watching how well the streamlining is working, and as we are potentially as a commission going to be trying to ask for more resources so that we can be in a much reduced backlog, I would like to see a quarterly update for a while, as long as that's not overly deterring your team from taking them off the case, for example.
I will certainly look into that. We already provide an annual report to the legislature with this type of data. So I can work with my staff and see if that's something that we can do more frequently, but we can certainly provide that to you. 'Cause I believe you weren't yet on the commission when we last produced that, because it's early January.
Yeah, I did read that one actually, and thank you. That was very helpful. Where just in my mind, I'm thinking of the next budget cycle. You know, we're already a good way through this legislative budget cycle. It's been an uncertain time. The budget will get adopted by mid-June if the law is followed. And so we might be starting to anticipate what we as a commission need to know and see and the pattern, so that when the budget is being developed late this year for the following year, those initial conversations are happening, we're already involved in them. So thank you for that.
All right, additional questions for Chief Brereton? All right, Chief Brereton.
Okay. So the next section is penalties. I realize we are past 1:15, so I will be as quick as I can. So in general, we use general criteria, the facts and evidence of the case, and commission direction to reach the penalties that we propose in settlements as well as at hearing. Our general criteria are in the regulation. So, you know, we use this in all of our mainline steps. We use it in all of our, when we're evaluating a case, to figure out like where it lands in the penalty range. What I want to stress is that our penalties are fact dependent. They depend on each case, and we use our prosecutorial discretion to determine like how do these factors apply. But because we have these factors, our prosecutorial discretion has parameters. Like we have guidance to be able to help us to create a proposal that is fair and consistent with other cases that we have prosecuted previously. And the check and balance on that is that we bring all of our proposals to you for approval. And as we saw earlier today, if we're not going in the direction that you would prefer, you can weigh in and say, no, we want this to be higher, lower, whatever. And so that the balance of all of those together help us to move forward in a manner that's consistent so the regulated community knows what to expect. We do focus our attention on on cases that have a higher degree of public harm. So campaign-related communications at public expense, personal use of campaign funds, conflicts of interest, campaign contribution laundering. These are all areas that the commission has given us direction in the past that these are priorities for us. And again, hopefully our streamlined programs will help us to be able to focus more of our energies on these than the lower public harm cases. This is just a quick example of how we reach a penalty using the factors. This is particularly conflict of interest cases. We looked back at a few years of conflicts cases to see like, well, which cases had higher fines, and they involved things like not disclosing the interest on a statement of economic interest. There was a large personal benefit to the official, or there's a pattern of violations. So those will increase the penalty range for that type of violation. And then there are mitigating factors as well. There's no prior history, or they're very cooperative, or the interest was disclosed. They weren't trying to hide that they had an interest in company XYZ. So those will also be taken into account to lower the penalties. Before I move on, does anyone have questions about the penalties? Okay. So lastly, looking forward, we'll have special elections in 2021, and then 2022 will be another statewide election cycle. So we anticipate more complaints. If history serves, referrals are just going to keep on coming. So we'll keep dealing with those as well. The new local contribution limits went into effect in January for the statewide level. So we expect to start seeing some complaints about those too. We'll continue with our AdWatch and our proactive programs, our expanded streamline programs. We're very excited to see how those start to play out and relieve some of our resources so that we can focus on violations with high public harm. We're also looking forward to a new diversion program that's in development so that, again, that can free up some more resources so we can focus on higher public harm cases. And that is everything we have for you today. I can certainly answer more questions if you have them.
Thank you, Chief Brereton. Commissioner Cardenas?
Yes, Mr. Chair, thank you. Ms. Brereton, if you can go back to, I believe it's slide 30, perhaps?
I'm trying.
Yes, this is the one. I'm wondering if there should be some kind of a disclaimer at the bottom with respect to the icon for campaign contribution laundering, something along the line. Yeah, no, come on. Something along the lines of any similarity to current or past office holders, right, is purely their own fault. I shouldn't be so cavalier. I'm afraid I think I voted for that guy. Here's a question I had that isn't necessarily restricted to this particular slide, although I am rather fond of it. The chair has made a point of making sure that we are elevating ourselves across the board to best practices. And so in that regard, and this could have been asked of Jeffrey or Luce, all of you. For example, COGO, is it COGO, the Council on Government Ethics Laws? I believe Suki is a ranking officer of that. Is that right? Are organizations like that helpful, or how else are we at a staff level making sure that we are looking outside of our silos, seeing what colleagues around the state, around the country are doing to make sure that we continue to be among the very best?
We do work with agencies and outside of our state as well as within. And we're constantly in contact with them regarding investigations or fact patterns that might be coming up. So we do work collaboratively with the other ethics organizations to try to be on the same page, to try to see, well, what are you doing in your jurisdiction? How do you handle this situation? So we do work collaboratively so that we can try to be a united front, for this type of issue. It also helps too because issues that are important in one jurisdiction might not be as important in another. So it helps us to determine, like, if it's a matter of, say, we received a complaint, but maybe it's one we either want to work jointly with another agency, or maybe we want to turn it over completely to another entity to handle, because that's an issue important to them on a local level than it might be for us on a state level.
Thank you very much. Mr. Chair, if I might, one more question. Thank you. Do we have, I'm thinking about your backlog chart, which is very illuminating. But in terms of the data, I know Commissioner Wood is very much into the data, right? Yeah, this is for you. In terms of the data, do we have complaints, cases broken down geographically? And is my anecdotal sense that things smell down here in LA more than they do perhaps in other places in terms of political ne'er-do-wells? Does the data suggest that, or am I an outlier and I need to have a rosier outlook?
I have not run any reports along those lines, but we can because we do keep track of where of the jurisdictions for the various complaints and cases. That is a field that we have in our database. So I will work with my staff, and I can get some reports along those lines to you and see if it matches up with your feeling.
Yeah, if my colleagues think there's value in that, that could be very interesting.
Great. Commissioner Baker?
Yes, I would welcome seeing that as well. And Lord knows I would never come to the defense of Dodger fans, but I do know that the Bay Area has had its time as well, just in the, several years ago. So it is good it's smart. I think a great question by Commissioner Cardenas to be looking for where there are some geographic hotbeds, because the political consulting world, treasurer world, campaign training schools, and party activists within a region may all intermingle quite a bit. And it would be important that we not be blind to that. So good question.
All right. Commissioner Wood?
I guess I just want to give us a little bit of, I, of course, would love to see the data, but just a little bit of, not pause, but just caution when we look at it, because the same networks that exist might also be generating more complaints regionally, right? And so it's not like a random process that comes up to the enforcement division, and then the enforcement's decisions on what to, close and which ones to go after is also not random. And so what we'll be seeing is like some data that's been through a lot of different steps of a process. And so we just, it won't necessarily be indicative of where it is stinkier, right? It will just be indicative of where the complaints have come from and what the enforcement division has decided to do with those complaints, which isn't really equally distributed based on corruption. Sorry to geek out, but helpful, I hope.
I would like to interject just a moment. One of my amazing staff just sent me an email reminding me that we do have a heat map on our website by county. And if you go to the transparency page there, you'll find the heat map.
Great. Commissioner Wilson?
Okay, like Commissioner Baker, I'm a Northern California product, and I'm assuming, Ms. Brereton, when you look at this data for potential hotspots, it will take into account, the per capita for a particular area, because obviously a smaller county, for example, Tuolumne County is not going to have the same numbers as, let's say, Los Angeles County. But I do agree with, Commissioner Cardenas's recommendation and, the other commissioners that this data would be helpful to assess.
I will keep that in mind. Thank you.
Great. And I think, Ms. Chief Brereton, I appreciate all the information in your presentation today. It was very thorough. It's certainly a lot to think about, a lot to digest there. I just want to offer to the other commissioners, after today's meeting, if there are particular areas that you want more detail on, I'd encourage you to reach out to the Executive Director, and she can help work with Chief Brereton to prepare that additional information for us for a supplemental report to be presented at a future meeting. So today, the point is, today is our only opportunity. We can continue to get this information and drill down on it. So, Commissioner Wilson, did you have something further? I wasn't sure if you were raising your hand there.
No.
Okay, sorry. All right. Any further questions or comments for Chief Brereton? Hearing and seeing none. Chief Brereton, thank you, and thank you to your staff. A great presentation. You guys are doing a fantastic job.
Thank you. I appreciate the opportunity.
Thanks. All right. We'll now move to item number 8. This is our pre-notice discussion of regulatory changes for disclosure of online content. And I believe we will have Commission Counsel Torrin Lewis on the presentation. Mr. Lewis, good afternoon, sir.
Good afternoon, Mr. Chairman and Commissioners. As mentioned, I will be discussing some issues and proposed regulatory changes concerning disclosures on electronic media advertisements and some related communications that actually do not meet the definition of advertisements. So what I'm going to do is to share my screen so that you can actually see, hopefully, a PowerPoint presentation that we have prepared for today to serve as a visual aid for certain parts of today's presentation. Just let me know if everyone can see that, I hope.
Yep, we can see it.
Excellent, excellent. So again, this presentation is really a follow-up to the conversation that we had with the Commission at the March 18th Commission meeting. And in response, staff has gone back and drafted the memo before you now, which includes some proposed regulatory changes. And really the purpose of this memo, as well as the proposed regulatory changes, is to facilitate discussion that will allow the Commission to provide additional guidance to us as staff prior to presenting final versions of actual regulatory language for approval at a subsequent Commission meeting. So to summarize, there are more or less 5 proposals contained in our in our memo. The first is amendments to Regulation 18421 to add greater specificity to the heightened disclosure requirements found in that regulation, such as capturing the handle of a social media influencer who is paid to post content by a committee, or the title, for example, of an article written by a third party on behalf of a committee. The second is to harmonize these disclosure provisions found in Regulation 18421.5 with the advertising disclosure requirements of the Act where there is overlap. Third, to codify the legal division's informal advice that in a case where an influencer, social media influencer, is paid by a committee to post favorable content, that the influencer should tag or link back to the committee that paid them. Fourth, we recommend codifying legal advice that, again, informal legal advice, that disclosure for a paid website or blog post that meets the definition of an advertisement, that disclosure must be located at the top or the bottom of each individual post, as opposed to simply at the top or bottom of the site. And finally, similarly codifying legal division informal advice that advertisements in the form of videos, no matter where they are posted, must follow the rules, the appropriate rules under the Act, including videos posted to social media. So I'll go into a little bit more detail for each of these proposals, but I'm happy to pause for any questions or other instruction from the commission. So
Well,
first,
Mr. Liz,
Sure.
Mr. Liz, can I just so I'm make sure I'm following along, maybe for the benefit of the public too. You identified 5 different regulatory proposals. The first 2 go to information that would be reported on the campaign reports that are being filed. The final 3 go to increasing the types of information that is communicated on the actual content, if you will, itself. So it's sort of both sides of the equation. It's what's reported after the fact and then what the end user sees. Is that right?
I think that's correct. One sort of nuance that I would add is on the third recommendation, which is codifying legal division advice that an influencer tag or link back to the committee that paid them. We really view that as just effectuating the disclosure requirements of the Act with respect to the committee having to provide disclosure, but not really, we don't really view it as a new requirement of the party who is doing the tagging, if that makes sense.
It does. That's a correct nuance. My point was one thing, the first 2 items are changing the requirements of what's reported on a campaign report. So if you wanted to see that, you would go and look at the campaign reports. The other 3, the final 3 that you're pointing out, are ways of providing information on the content itself, just as a way to clarify what the expectation is for folks.
Yep, that is absolutely right.
All right, thank you.
So to briefly provide some context for each of these, with respect to 18421 and the proposed changes to that regulation, again, this is a regulation sometimes referred to as the blogger regulation. Of course, it encompasses more than just blogs, even though that was probably the primary vehicle contemplated at the time of its passage. But really, this regulation requires heightened disclosure, as the chair mentioned, on campaign statements when a committee is paying an internet website for favorable content. And so in essence, this regulation requires additional details surrounding the expenditures of a committee in that circumstance. But in addition to that requirement, Regulation 18421.5 subdivision G also permits a committee to satisfy that heightened reporting requirement by instead ensuring that a type of disclosure statement is placed on the communication that it's paying for itself. So in other words, the regulation can be satisfied in one of 2 ways. But since the passage of the blogger regulation, we've found that the platforms on which such paid content usually appears has really expanded beyond blogs to other electronic formats, and that includes social media, community news sites, and others. And in addition, we've identified a lack of transparency in circumstances where a committee pays an influencer, so-called influencer, to post an something that qualifies as an advertisement on the influencer's own social media profile. And because of these issues, we recommend amending Regulation 18421.5 in two ways. As mentioned, first, expanding these heightened reporting requirements to include additional information so the public can better identify the connection between the committee and the poster. And so that would include, for example, the poster's social media username and handle or handle. In the case of someone who is paid by a committee to post an article or an op-ed, which is, I think, something Commissioner Baker, we had a conversation about this last time. In that case, we could also require the title of the op-ed or the article to be reported as well. And this is all in addition to the name of the payee and URL and so forth. Secondly, we could require this information rather than simply upon the first instance of it being posted. We could require this every single time such content is posted. And secondly, and this is where I'll lean on the visual aid here, in the case of a communication that is covered by the so-called blogger regulation, but also meets the definition of an advertisement under the Act, there's overlap between the disclosure requirements for both. And so I've juxtaposed them here so you can see for yourselves. But we recommend clarifying that where both rules apply, the advertising disclosure rules of the Act still apply to a communication covered by this regulation. Just to make very clear that an advertisement couldn't just get away with satisfying the optional disclosure requirement of 18421.5 and not have to comply with the Disclose Act. I'll pause there to see if there's any questions on this before moving on to other proposed changes.
Any questions for Mr. Lewis on this portion of his presentation? All right, go ahead and continue, Mr. Lewis.
Okay. So in addition to the changes to Regulation 18421.5, we also recommend, as mentioned previously, codifying some informal advice that the legal division has issued on some more bringing the rules more up to date with some situations we've seen. And so one of these situations is that the Act doesn't explicitly address advertising disclosure on social media posts by a third-party influencer who's paid by a committee. And so the committee who's paying for the advertisement, as mentioned, is required to have a disclosure on its social media profile or landing page. But there's not necessarily a way for the person who's viewing the influencer's post to discern the connection between the poster and the committee that paid them. And so informally, we have advised that if an influencer is paid by a committee to post on social media, the influencer should tag the committee in the influencer's post so that voters can link back to the committee's profile or landing page to see the actual required disclosure on the part of the committee. And so we propose drafting a new regulation or multiple regulations, depending on what's best, codifying that guidance. The next scenario that's arisen is that.
May I interrupt, Mr. Chair? Quick question,
Yes,
if I may.
please, Commissioner Baker.
I want to just be sure I understand the difference in terminology between tagging the profile or landing page, because we're using the terms synonymously. And I know in law and policy, a kind of committee meeting we had earlier, we were doing the same and created a little bit confusion for me. When I think of, let's say, tweeting a post and tagging the handle, the Twitter handle of the person who, let's say, maybe paid me to do it, that will go to their Twitter account that has a bunch of information, but I find that different from a landing page. To me, that's a profile versus landing page. Landing page could, in my mind, maybe any page I put up that I want to link it to. Let's say it's one that says this ad was paid for by Catherine Baker for Dogcatcher, 2022. So I wonder if you can just make the clear distinction between a profile versus landing page, or if I'm wrong and they really are the same thing.
I defer to Suki Brar on this question, or actually, I don't know if she's with us.
Yeah, I'm here. Hi, Commissioner Baker. Those are basically the same thing. They're just different terms for the same thing. It's the profile page of the committee on that particular platform.
Okay, got it. So in my example, it's if I tag the Twitter account of Commissioner Wood, it's going to go to her Twitter page, and it could have all of her, basically her whole thing. It's not going to a specially made page that says paid for by so-and-so.
Yeah.
Thank you.
Welcome.
Ms. Brar, can I ask you a question real quick? I just want to clarify some. I think I just understood you to say that the terms landing page and profile page or profile mean the same thing. Is that right?
Yes, in this section, yes, I do.
All right. If we move forward and we end up codifying this advice in a reg, it's a ticky-tacky thing, I know, but pick one term. Because I think I was with Commissioner Baker. It's like, well, if we're using two terms, that denotes two different things. But if it's just one thing, let's just pick one term and stick with it.
Okay.
All right, thanks.
Oh,
Commissioner Wilson?
yes, on that same point, Chair Matich, excellent suggestion. But I also think it would be a good idea to have a clear definition spelled out, because someone reading the regulation, assuming we go forward with any changes, might misinterpret the use of the term. But if it's defined, there, that eliminates that possibility.
Okay.
Yep, I agree, 100%.
Okay, thank you.
Just a small point of clarification, if I may, Mr. Chair. So,
please, Commissioner Wood.
If it is to my campaign page, or excuse me, if Commissioner Baker is paid to run an ad or to run a tweet or whatever about my campaign for, well, you've already taken dog catcher, I don't know, tax collector, right? And she's, does the with my Twitter feed, I am also separately obligated to link to my campaign's webpage that contains the full disclosure and disclaimer or whatever, right? Ms. Brar, isn't that true? There's like a separate regulation that gets you out of Twitter and onto whatever my campaign's website is.
So the general rule is that the full disclosure should be on your profile or landing page. And I believe that if for some reason it cannot fit there, you could possibly link to another page, but only in that case.
Okay, so like a small items exception, but basically it would have to have like my FPPC number on my Twitter profile or something.
It would have to have not the FPPC number, but the name of the committee.
The name of the committee, okay.
And possibly other items such as top contributors and IE messages, depending on the type of committee that it is.
Okay, thanks.
Mm-hmm.
All right, Mr. Lewis, please proceed.
Okay, so the next slide you should see before you is the text of 84504.3D. And this is important because it specifies that in the case of an email message or website paid for by a committee, the disclosure requirements required thereof under the Act have to be at the top or bottom of the email or the website. But where so referring back to our previous conversation, say in the context of blogs, if a third party pays, if a committee pays a third party to post content, say on a blog, it's not clear exactly where that disclosure should be located. And let's see, as an example here, if I can get this up. So I have as an example, this is a state agency's blog. To be very clear, this is would not be an actually relevant example, but I chose it specifically because there's nothing controversial or political here, but we can walk through it as if there was. So this is the Department of Consumer Affairs blog. But as you can see, there are multiple posts here on this site. And so if there were a disclosure statement at the top or the bottom of the website, as is currently required, literally by 84504.3D, that wouldn't necessarily be clear to a viewer of an individual post, such as I'll take this one here, where to find that information. And so we being the legal division, have informally advised that a committee could satisfy the requirements in the case of a communication that falls under, again, both the blogger regulation and would fall under the Act's advertising disclosure requirements, could satisfy both of those by including an ad paid for by disclosure statement within the individual blog post, rather than at the top or the bottom of the website. And so again, we recommend codifying this advice by adopting a regulation specifying that individual website posts or blog posts that meet the Act's definition of an advertisement have to have disclosures on the individual posts themselves. And then we can further specify that the location of that disclosure should be at the top or bottom of the individual post, rather than, every page of the website. I'll just leave that up there, but the next issue does not pertain to that example. So similarly, the legal division has received a lot of questions regarding whether videos posted to social media that qualify as advertisements under the Act only require disclosure on the landing page of the committee or on the actual video itself. And again, we have advised that advertisements in the form of videos, no matter where they're posted, have to follow the video rules, including videos posted to social media. And so similarly, we recommend drafting and adopting, or actually, this could also be an amendment to 804, I think it's 18450.4, specifying that a video posted on social media has to contain the disclosures on the video and not only on the poster's profile page. And this is in essence just, we believe, a clarification or a restatement of the existing requirements under section 84504.3G of the Act, which specify that electronic media advertisements in the form of videos have to comply with specific disclosure requirements for videos, depending on the type of committee that paid for them. And so the last point I have is that only requiring, actually I do have, just remember an additional slide here. Here we go. So one limitation or one, issue we've noticed in the law is that section 84504, I'm struggling with the numbers today, 0.3 H1 specifically states that the required disclosures for electronic media advertisements shall not be required on each individual post, comment, or other similar communication. And so if the commission is interested in pursuing legislation in this area, one fix would be supporting legislation amending section 84503.3H to require disclosure on each individual advertisement posted instead of just the landing page. And I think that's all I've got. I'm happy to answer any questions.
Additional questions for Mr. Lewis from commissioners? Commissioner Wood?
Thanks. I have two small things on this slide that you have up. I don't know where the echo is coming from, sorry. So the way I read page 3 of the memo was that you guys wanted us to go ahead and, or you were going to go ahead and propose a regulation that required the blog disclosure. But you also were very quick to point out that it seems to be expressly forbidden by this provision we're looking at right here. So I'm wondering how you want to navigate that. Is that a timing thing, or is there some kind of interpretive trick that we're going to be able to use that I don't know about? And then to the extent that we're able to do it, I just want to put a strong plug in for putting the blog disclosure at the top rather than at the bottom of the post. I don't think a lot of people read all the way to the bottom anymore. So those are that's my two kind of issues on that. I have one other thing I'd like to raise, but I can wait until we're done with the blog issue.
Yeah, again, I think I'll defer to Suki Brar or General Counsel Bainbridge on that one.
Yeah, so I'll just add, a blog can be done in different ways. It can be on social media, or it can be on a website that isn't technically social media. And so that top or bottom issue that we were discussing, that would be on non-social media blogs. So blogs that are on a traditional website type of style.
Okay. And then what about this issue with the interpretation of the act as it currently stands, as opposed to some amended version that we would hope would clear the way for regulation in this area?
Yeah, that was my mistake. I unmuted out of habit there on the Zoom. And Sasha gave me a dirty look, as she usually does. We're talking about two different things. Our reg suggestion on the social media posts is that we include the tag so that someone who sees the social media post on the third party who's been paid by the committee to run the social media post tags back to the committee that paid for it, where they would have to have the disclosure. In our mind, that's not requiring a disclosure. That is facilitating for someone to see the disclosure that is required by the law. And we had at our law and policy meeting, one of the major proponents of the Disclose Act, who acknowledged that they didn't really think of this issue of committees paying other people to run advertisements for them on their social media when they drafted the language. So what our regulation is proposing is essentially, by having that tag, is a way to lead people to the disclosure that is required by the law. Currently, there's no way to even direct you to that disclosure if you're looking at an advertisement on a third party's social media platform. So in our mind, I think it's consistent with the law that we facilitate people being able to see the disclosure that is required. And then the other part, and I think this is something we discussed last time, is better than that would be requiring the disclosure on the posts themselves, because that actually says this was paid for by a committee. All our proposed regulation would do is tie you back to the committee's page. It doesn't necessarily tell you they've paid for this influencer to say great things about them. And that would require a statutory change, and that's what we would recommend, a statutory change. And if people think it gets people's attention better if it's at the top of the post, we certainly would discuss that with any authors that are interested in taking up this legislation.
Thank you. That's really helpful. Another issue I have, just as like of concern generally, that I don't think any of this touches, but maybe I'm not thinking creatively enough. I feel like sometimes I get in this digital transparency world and I kind of grasp with the zones that we're talking about, as I kind of just did in the last thing. But is the idea of bots, right? So it might be that, or maybe I just want to encourage us to write any regulations that we do on the expenditure disclosure side to be inclusive of payments that happen outside of platforms for amplification of speech, right? Or amplification of a blog post or an op-ed that someone puts up. So it's not just that we want the disclaimer or disclosure or link back to the campaign, but we also want to be accounting for paid amplification. And of course, a lot of that paid amplification is going to violate the terms of service of the social media companies themselves, but a lot of it happens anyway. And so we'd like to be able to know if that's happening. I don't think that maybe that's already something you're thinking about. I'd love to hear you talk about it, but in general, it's something I'm really interested in. I mean, apparently something like 40% of users of Twitter are bots, and then they'll do a crackdown and it'll go down to 30%,
Commissioner Wood, can you explain or give a concrete example of what you're referring to? Because it sounds to me like I think what you're saying is the bots are sharing the content that we're concerned about across wider audiences, and we're not able to track that. But I don't know because I'm not technologically savvy. So can you just what do you mean?
Right. So when I haven't really haven't dived into this for like 3 or 4 years. So the technology may have changed again, but back when I was writing about it, it was bots and sock puppets, and there were these amplification networks. And sometimes it would be people, and oftentimes they'd be sitting in foreign countries, just logging into, they would each have 100 Twitter accounts, and they would log into each of them and retweet. It was often the president's tweets, right? But not always. It was sometimes just misinformation about various things. And so that's when a human is involved. And there's also a way people can automate accounts to retweet anything that some other account tweets, and so you end up with these networks. And so you can go and you could Google this right now, how do I buy retweets, or how do I buy faves, or how do I buy likes, and you can just purchase them to amplify your own social media. And so what that ends up doing is giving a whole lot of reach to ads. Now we got to think about the boundaries on it, right? I mean, issue speech is different than candidate speech and things like that, but it's just this zone where there's a whole lot of amplification. The expenditure to do that amplification seems like it could be invisible to our eyes currently, based on the way that the expenditure disclosures are currently happening. I hope that's helpful.
Yeah, so that is helpful. I think that's fascinating. I had no idea that was happening. So I guess my question is, would part of the proposed solution to that to have the sort of going back to the first two regulatory proposals Mr. Lewis was talking about to increase the detail in the reports would include enhanced detail when payments are being made for purposes of amplifying a message. Is that what you're talking about, at least on that piece?
Yeah, I think that's the way we would do it. I mean, I know that sometimes when the platforms come and talk, to potential regulators about these issues, they say things like, well, we capture all of the payments that happen on our platform. But the transactions I'm talking about happen off platform. And if I were being sneaky, if I wanted a whole bunch of bot amplification or a whole bunch of followers, you can also buy followers, right? I would just try to disclose that expenditure very vaguely, because it's I want to look really popular on social media, but if I'm just buying all this love, right, then I think the public might look poorly on that, and so I'm just going to call it like marketing or something. And so we might, to the extent that we think that's important, we might want to incorporate that when we write the regulations around these expenditure disclosures.
Interesting. I think that's good. I agree with that.
Yeah, I think that's very interesting. That's not something we had contemplated. I think we probably will now look into that. I think, as you indicated, in some way, expenditures, of course, are going to be reported. But as for the detail, I couldn't speak to how exactly people are reporting those sorts of activities now.
Right. Yeah, I think when we think about it, like about paying influencers, we're missing what this thing is, right? So influencers are like, have a zillion followers and they're real people and they're well known and they're influential. And this is just a megaphone attached to whoever's originally saying the thing. And it might be an influencer, but it might just be the candidate or the campaign or some outside group. I'll send you an article. Say what? Sorry, Chair.
Yeah, no, sorry. I'm just curious. So we've talked about the enhanced disclosure as part of the solution here. My question is, in your experience, when you've been looking at this, when you're amplifying, and particularly in campaign speech, paid content through these bots, are any of the disclaimers dropping off during the amplification process, or that's not so much the concern, that if there is a disclaimer in the first instance, the amplification process, that disclaimer is going to continue being on the post?
I guess that's true. I hadn't really thought about that. But if it's retweets and likes, then they can't edit the original post. Another thing that happens, this happened really recently in LA County. I guess, I forget which city or cities it was, but they were talking about, getting rid of gas stoves in new developments and switching everybody over to electric. And there was a whole network that was paid to get on Nextdoor and start writing posts about how much they like to kind of cook with gas. And none of that was disclosed to my knowledge. I'm not sure. I feel like now that I have a little regulatory power, I should be careful, right? But that kind of thing, see, that's more issue speech in nature. And so I don't really know what to do about that, but I just want to give like another flavor of this, right? Again, these people weren't influencers. They were being paid for this speech. It affected a political issue in this context, right? But when I feel like a lot of these conversations have had influencers in our mind, but I think the bigger issue may be these kind of nobodies who actually may be nobodies who are amplifying existing speech.
Right, that's a good point. All right, do other commissioners have any questions or feedback for Mr. Lewis on his presentation? Commissioner Baker,
Yes,
I can't see you, but I'm told you have a.
I'm sorry. I hope I'm not frozen in some really horrifying pose, but I thank you. And it's fascinating discussion about bots. I don't think I'm being a contrarian with this, but I think before we try to wrap that concept potentially into this effort to produce regulations, because this is a pre-notice conversation and there's a bit of a timeline that we might be on, I would like to know much more. I'm thrilled that we have a great resource as a fellow commissioner for this, but I think when we start to potentially suggest more disclosure of expenditures in different areas like bots, I would need to study it more and ensure that more disclosures is the way to go. And if we're going to do it on bots, then where else do we start to draw the line on a certain amount of disclosure in the campaign reports, is inadequate? So because I would want to have some kind of defining principle. If we're going to do that with bots, where if you're going to pay to have someone to magnify or amplify, as you're saying, or some technology to do it, how is that different from some other campaign expenditure? So I need to explore it more before putting it into this particular regulatory effort. But I'm thrilled. I would never have thought of the topic. Second is some of the questions that I will look forward to hearing about as this regulatory process goes through. If we are going to be talking about requiring certain disclosures on each social media post, there's character limits. And if somebody wants to come forward and say that constrains their speech, and that, that we will need to be mindful of that, I will be curious about that. If some of the feedback we'll get is we are imposing speech in a confined space as opposed to tagging that then goes to a different type of disclosure that way. So I want to be mindful of that. And I'd like to ask that our team, as they're contemplating these issues, to look at that possibility. The effect that requiring the post on the disclosure paid for by on every single post could constrain speech. And I want to thank you for also, when we come back to this topic, presumably in law and policy in this commission, full commission, that at every opportunity we have that visual, so we are all conceptualizing the same thing. So for example, just as you did, and in some of the materials that were provided in our March meeting, here's an example of the Twitter post or the blog post now, and here's what it would look like under our proposed regulation. I would find that helpful, and I know we're partway there. So thank you.
Thank you. Other questions or comments for Mr. Lewis as part of his presentation? All right. Well, Mr. Lewis, what you've brought to us today are the concepts that staff is prepared to reduce to regulatory language for presentation at a subsequent commission meeting. I would ask that staff prepare language to address the bot issue that Commissioner Wood raised, without prejudice to Commissioner Baker and others who, at the time, when it comes back to us, maybe we decide not to approve that portion of the regulation. But I think it's a useful exercise to at least be able to see what it would look like, just so we can kind of wrap our heads around it and continue to get information on that issue, because I do think that may be something we want to look at. So, and I see it as really connected to this reg. Now, whether we do it or not is a separate question, but I think it's certainly germane in my mind.
Certainly, yeah, we can do that.
All right. All right. Any other questions or comments for Mr. Lewis? Going once, going twice. All right. Is there any public comment on this item? And we are on item number 8. This is our pre-notice discussion. Hearing and seeing none. Thank you, Mr. Lewis. We look forward to you coming back next month on this. Thank you.
Not a problem.
All right, moving on to item number 9. This is the In Re Sanders opinion, and I'll turn it over to our general counsel, Mr. Bainbridge.
Okay, we are back for round 3 on this one. This opinion concerns a question of interpretation regarding AB 571. Those numbers are probably familiar. That is the legislation that went into effect in 2019. That was adopted by the legislature and the governor in 2019 and went into effect January 1st, 2021. And what it essentially did was impose the existing state limits on city and county offices where the locals haven't adopted their own contribution limits. The issue that we've been grappling with over the last few months is how to deal with how to apply the limits when contributions were received before the January 1, 2021 effective date of the legislation. This problem is created because limits are per election, and contributions for an election occurring next year or multiple years in advance can be made. So the limits follow the elections, and then the legislation follows the Gregorian calendar. So it creates some interesting issues that we've had to. Yeah, that one was for you, Commissioner Cardenas. I put that in there specifically. I thought you'd like that. So the question that we received was how do we deal with contributions that were for an election after January 1, 2021, when it was made in advance, when the contribution was made before that date. And the legislation was not explicit on this matter. So what the legal division has advised beginning in December of last year and over the last few months here is that contributions that were made before the effective date for an election after the effective date were not subject to any limits. That was the easy question. So you could give an unlimited contribution before January 1, 2021, even though the election was being held after that date. The other question that we received was, do we then, if someone gives a contribution before that date, regardless of the amount, and then gives a second contribution after the effective date of the legislation to the same candidate for the same election, do we then consider the contribution made prior in determining whether the subsequent contribution would exceed the contribution limit that is now in effect? So do we count the money that came in before for purposes of over the limit contributions, or do we pretend like it never happened and start fresh January 1? Every candidate would get the full contribution limit of $4,900. What the legal division advised after looking at the issue was that the legislation, although not clear on this specific topic, or not explicit at least, the intent of it was to aggregate the contributions, and that was the best reading of the statute as drafted, given some specific drafting issues as well as the overall intent of the legislation. The California Political Attorneys Association heard about this advice and disagreed with it and submitted a comment letter, actually when the regulations were up on this issue a few months ago. So at the direction of the commission, we've drafted two opinions, one that reflects the legal division's advice as described more thoroughly last month at our March meeting. The second version reflects essentially the opinion of the California Political Attorneys Association, which says not to count the activity that occurred before January 1, 2021. Like I said, the legislation is not explicit, so both of these opinions are interpretations based on what we could gather from legislative intent and all those other things attorneys look at in trying to decide questions that are not clearly laid out in the legislation. One thing I will mention before turning it over to the commission for questions is there has been some assertions that this would implicate First Amendment violations potentially, particularly as to the first interpretation. That's not the case. And this gets back to the underlying basis that the Supreme Court has stated for contribution limits placed on contributors. And that is, a contributor is allowed to make a contribution as a symbolic gesture of support or association with the candidate. But contributions can be limited, and in fact, the Supreme Court on many occasions has said contributions can be limited because at a certain point it goes beyond a symbolic expression of your support for a candidate and starts to get into concerns about quid pro quo. So that is the basis for contribution limits and having First Amendment protections. And I explain that to get to the point that neither of these interpretations would prohibit anything less than a contribution up to the limit. They wouldn't even be applied until someone has given a contribution of at least $4,900, and the question is just whether they can give more than that by making a second contribution. So the contribution limits are, as long as the contribution limits are valid, which we've had state contribution limits for a long time and they haven't been overturned by the court, there's no reason why prohibiting additional contributions on top of that would somehow trigger or deny someone their First Amendment right to make a symbolic gesture of support as it's described in the Buckley v. Vallejo case. So I just wanted to address that issue to ensure you, depending on which opinion you choose, that neither of them, based on our analysis, have a First Amendment issue and would not violate the First Amendment rights of the contributors. So with that, I think I've talked about this enough over the last few months, so I'll just turn it over for questions.
All right. Thank you, Mr. Bainbridge. Question on procedure. I think this is the first time we've had a formal opinion request, at least since I've been chair. And so procedurally, do we, at this stage, take comment first from the requester and then consider the opinion, or does the commission consider the opinion now and then we simply take public comment after that?
I think it would make sense to allow for public comment before you making a motion on which opinion to adopt. I think that would make sense. I think you could do it either way. You could make the motion, and then if they want to comment, they may, or maybe they don't want to comment once they hear what the motion is. But either way is fine. I'll leave it up to you.
All right. Unless my fellow commissioners object, I'd be inclined to call for public comment now at this point so that we have the benefit of hearing the public comment before we deliberate. All right, without objection then, let's go ahead and call public comment on item number 9. This is the opinion request in Ray Sanders. Do we have any public comment?
Hi, Chair, Commissioners, Mr. Bainbridge. This is Nick Sanders from Sutton Law Firm on behalf of the California Political Attorneys Association. I first want to start by highlighting that this type of debate regarding vagueness in one of these campaign finance laws, it's incredibly important for the regulated community and the public. So I want to thank the Commission and I want to thank staff for all the hard work in presenting and discussing this. These are difficult issues. There's a lot of different interpretations, and we just want to say thank you. I have two just additional thoughts. First, we respectfully disagree with Mr. Bainbridge's interpretation on whether the First Amendment may be violated here under Alternative Draft 1. Just on its face, there are going to be different contributors whose contributions are treated differently, depending on when they gave. So there are going to be First Amendment issues, and we think that we've laid them out in the comment letter. We think that the base limits starting on January 1st, 2021 are a prophylactic measure. So anything else is in addition to, sort of like the McCutcheon case. I obviously know that there are differences between the two cases, but we think that it's a good case to look at in this. And second, this is just kind of general speaking towards the comment letter. I've spoken with other attorneys at other firms, and I think that the general consensus is that there is kind of certainty that there were contributors that have already contributed more than 4,900 before January 1st, 2021, and so they would be prohibited from giving contributions when the 2022 election really kicks in. So what I had laid out as a hypothetical, we don't have specific examples that we can give, but it's a relative certainty among the practitioners that this is occurring. So thank you again for everyone's time and effort. We think that this is very important, and so I will leave you to your debate.
Thank you, Mr. Sanders. Do we have any additional public comment on item number 9 before the commission begins its deliberations? All right, commissioners, go ahead and just open the floor. Does anyone wish to speak on this matter first? I will go first. I've reviewed both drafts. I think that this, as I think I said at the prior meeting, I think it's a close call with respect to retroactive application of this law. And I guess where I come down is I don't even think we need to reach the constitutional issue here. I think this can be resolved purely on a matter of statutory construction. And the legislature said that the new limits went into effect January 1st, 2021. They did not explicitly state anywhere in the legislation that I'm aware of that prior contributions would be aggregated for purposes of the new limits that went into effect this year. And so I take that at face value. I think the plain language suggests that the very first date at which we would even begin aggregating wouldn't be until January 1st, 2021. And so based on that view that I hold, I think that alternative number 2 is the better interpretation, I should say, for the commission to apply under these circumstances. So that's my view. Commissioner Baker.
Thank you. And I share that view as well. I found it was a close call, but not too close a call for me in terms of the statutory rules of statutory construction, and particularly persuasive to me was the plain meaning of the text. And most importantly, that we would be expressing a requirement that the legislature did not itself expressly put in there. And whether they intended to be ambiguous or leave it to someone else, or that they just didn't think of it, the fact to me remains it is not expressly in there. And we would be rewriting the statute in some respects in that way by writing it in there. That I found very persuasive, in addition to the other arguments that were made in draft 2. And that would be the one I propose that we adopt.
Thank you, Commissioner Baker. Commissioner Wilson?
I'm not going to parrot what the chair and Commissioner Baker stated, but if the legislature wanted this bill to apply retroactively, they could have clearly put language to that effect in the statute. And in addition, the legislature has the constitutional authority to have a bill take effect immediately. This bill moved through the legislature over about a 7-8 month period, and there were ample opportunities at the committee level and also during floor debate in both houses to clarify this issue. And for us to retroactively apply this statute, I think is inconsistent with what was clearly intended when this bill was enacted and signed by the governor.
Thank you, Commissioner Wilson. I think it was a good point about it not going into effect immediately. I hadn't thought about that, but I think that's a good point to make. Commissioner Wood.
So I am also going to be in support of draft 2, but it's less about, I actually disagree with you guys that it's an easy statutory interpretation issue, or like the, I think that the statutory interpretation could go either way. I wish the legislature would have been clear about what they wanted. I just wanted to make sure that I spoke to say that, the statutory interpretation in draft 1 that basically says like they know how to say this and they didn't, I think is equally valid to things like plain text. And so I really appreciate the difficulty of this task. For me, it comes down a lot to logistics in a pandemic, and that we don't want to be, hurting candidates who are already pretty belabored and, adding aggregation they might not have seen coming and things like that. And so to me, it just feels simpler if we just go with draft 2 and everyone kind of has notice and they know that it's coming. And just ask the legislature to be clearer next time if they would.
Thank you, Commissioner Wood. Commissioner Cardenas, do you wish to make, Commissioner Wilson?
I'll defer to Commissioner Cardenas, and then I have a question for Mr. Bainbridge.
All right, Commissioner Cardenas?
I'm sorry, you all lost me at the first utterance of the word bot. So you're all suggesting option 2 here, is that right?
Correct.
It has nothing to do with bots, is that right?
Also correct.
Excellent.
Thank you, Commissioner Cardenas. Commissioner Wilson?
Well, first of all, I want to state that Mr. Bainbridge has been very objective, along with his staff, in providing both sides of the options here. But I do have a question regarding the $4,900 limit, and if Mr. Bainbridge has any insight into the number of local jurisdictions that have pursuant to AB 571 established higher caps. In some cases, I understand tens of thousands of dollars above the 4,900.
We actually did. Did it again. Yeah, it's muscle memory with the unmute.
It was a bug.
Yeah, that's right. We put out a survey after last month's meeting to as many city and county clerks who we could easily find email addresses for. And we just got all the results back and collected on Tuesday about who had adopted ordinances. They don't break out in response to the new law or whether they had them before. What our numbers showed was, and this is, I think we had 86 jurisdictions that responded. So a pretty good sample size. We sent it out to 200 some jurisdictions. And when this legislation was going through the legislature back in 2019, the numbers were right around 75% of jurisdictions did not have their own limits. And what we found from the people that responded to us is it's now more like about 2/3 of jurisdictions don't have their own limits. So since this legislation, there's been a significant increase in the number of jurisdictions that have adopted limits. I don't have the numbers on how many are higher versus lower than the state limit. I can count that up and get that information to you. From looking at it, it seemed like most of the jurisdictions were adopting limits lower than the state limit. I saw a few that said, infinity, and a few that had very high limits, 30 to 40,000. But for the most part, if they were adopting limits, they were adopting limits lower than the state limit.
Okay, thank you.
All right. Any further questions or comments for Mr. Bainbridge on this item from the commission? Commissioner Cardenas?
I just wanted to suggest to Dave, you can call me a traditionalist, man, but for about 1,600 years, the Julian calendar was doing just fine.
All right. At this point then, unless commissioners have additional deliberations on this item, I would move that the commission adopt alternative number 2 as our interpretation with respect to aggregation of the default contribution limit put in place by Assembly Bill 571. Do I have a second?
Second.
Second, thank you. Ms. Linker.
Commissioner Baker,
Sorry, I'm trying to get my mute off. Aye.
Commissioner Cardenas,
Yes.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Matich.
Aye.
The motion passes.
Thank you. Mr. Bainbridge, briefly, can you just very briefly tell us now that we have adopted this formal opinion, what happens next?
Sure. The opinion goes into effect immediately, and it gets published in 30 days. If any commissioners would like to write a dissenting, although that seems unlikely considering your vote, or their own concurring opinion, thank you. They may do so within the next 30 days, and that will be published along with the opinion. It gets published by being put on our website. For one, it goes to Westlaw and Lexis, and then we would also send it out over our listserv. We will also reach out to anybody who we have given advice on this topic and let them know that this opinion has been issued.
Great, and I think we also have a fact sheet on our website that would be updated accordingly.
Yeah, and we'll update any materials on the website as well.
Excellent. All right, thank you, Mr. Bainbridge. All right, moving on to item number 10 on our agenda today. These are the committee updates. We had 2 committee meetings this month, Law and Policy, which met earlier this week, and Public Outreach and Technology, which met last week. And so taking outreach and technology first, and that's Commissioner Wilson and I, we heard an update on the continuing efforts to update our website. Jay Waringa made a presentation on that, as well as Mr. Crabtree with respect to our search function that we have on the website and improving that in some ways. For the full commission's benefit, we are going to receive an update from Mr. Waringa again at the committee in May, and then we anticipate having website changes, proposed website changes, brought back to the full commission in June of this year. So we can look forward to that in a couple months. We also received an update on a campaign filing location reference sheet. This was something that Commissioner Wilson had recommended a couple months back, I believe, through our Outreach and Technology Committee meeting. And basically, this is a handy reference sheet for candidates and other folks to know where they file various forms, whether it's with our office or whether it's the Secretary of State or with the local clerks. And that was based on some feedback we had received that people can tend to get confused sometimes when some documents are filed with the clerk, some are filed with SOS, some get filed with us. So this is an effort to bring clarity to that for people. And then finally, we had a discussion about some of the advice letters that we had housed on our website. And the particular concern is if we have a change in a regulation or we've changed our advice, we have all of these advice letters on our website. And the question was, is there some way that we can either pull off old advice letters that are no longer relevant or highlight on each advice letter whether they involve a reg that has been changed or repealed, et cetera. That, what we heard, I think, in summary, is technologically that would be very difficult. And by their nature, advice letters aren't precedential. They're only really good to the requester. But what we are going to do is on the web page where people can search for advice letters, add some additional language if possible to remind people that when you're looking at old advice letters, always shepherdize the reg or the statute and make sure it hasn't changed so that you can continue to rely on it only when appropriate. So that is what we heard at Outreach and Technology. Commissioner Wilson, did I forget anything or anything additional you want to add to that?
No, it's an excellent summary, Chair Matich. I also want to, especially thank Mr. Crabtree, the head of IT and his entire staff for all of their hard work and the fact that they're very, responsive to creative suggestions. So thank you.
Great. And then, as I mentioned earlier this week, Commissioner Baker and I sat as our Law and Policy Committee. We heard a very thorough report from Ms. Nakano, our Legislative Counsel, on our different legislative efforts and those regarding the Political Reform Act. We also had Mr. Lewis do a sort of a preview of the presentation that we all had the benefit of today and provided some feedback to him as well. And then we talked about what we will be hearing next month at Law and Policy, which, if memory serves, we'll continue to hear a legislative update. We're going to receive an update on some behested payment ideas and work that the staff is currently engaged in. And then finally, a continuing update on the online ad disclosure project from Mr. Lewis again. So, Commissioner Baker, did I forget anything or anything you wish to add?
Nope, that's great. Thank you.
All right, thank you. All right, item 11 we took first today. So, Ms. Nakano, thank you for doing that. So moving to item number 12, our executive staff reports. Let's go ahead and begin with Chief Brereton.
Mr. Chair, if I may, I'm sorry to interrupt. There were two ex partes that I don't know if I needed to mention during the legislative discussion today. I know I mentioned them in the Law and Policy Committee for best practices on the legislation. I think it was AB 319. That was the bill to prohibit foreign principals from contributing. I had reached out to the legislative staff to inquire about a part of that bill that had been removed. That was disclosed at Law and Policy. And for a bill by Mr. Ben Allen that was on the agenda, it was in the report from Ms. Nakano that we did not discuss during her abbreviated report. I think it was 759. Before I was on the commission and I was on the Common Cause Board, there had begun discussions about that bill. I did not participate in them, and then I resigned from the board when I was appointed to this commission. I should have probably said that during Ms. Nakano's report, but I do it now since we're in full commission. Thank you.
Great. Thank you, Commissioner Baker. Appreciate that. All right.
Mr. Chair, if I might.
Commissioner Cardenas.
Mr. Chair, I noticed at least a couple of the bills that were in the report were actually being heard today. Perhaps that's why Ms. Nakano went over there. Is she back? Are there any updates by any chance?
Well, as a matter of fact, Commissioner Cardenas, Ms. Takano just walked back into the room. So you're correct. The reason that we took it early was because she had to participate in those hearings. So Ms. Nakano, would you care to give a brief update on how the committee hearing went today?
Sure. So the two items that were on consent, AB 319 and AB 1376, they passed on consent. The third item, AB 236, our sponsored bill relating to LLCs, that passed out of the committee 5-1. Assemblymember Sayarto voting no, and Assemblymember Mays abstaining. And that's all.
Thank you, Ms. Nakano. Commissioner
May I
Cardenas?
ask a question? Yes, thank you, Mr. Chair. Ms. Nakano, where does the LLC bill go now? Has it been referred elsewhere?
There goes my mic. It's been referred to the Assembly Appropriations Committee, and they will determine whether it needs to be heard there.
Great. Any other questions for Ms. Nakano? All right. Thank you, Ms. Nakano.
You see, what are you guys going to do without me? She was right in front of you.
Oh, Commissioner Cardenas.
I'm 500 miles away.
Commissioner Wilson, I wish.
Yeah, we're going to propose that the commission be increased from 5 to 7 members, and that you be able to continue to serve.
It's a very good suggestion, Commissioner Wilson. I second that. All right. Without further ado, then, Chief Brereton, if you care to provide your Enforcement Division report, please.
Yes, thank you. I just wanted to point out that, as I mentioned previously, we have started seeing some of the new expanded streamline STIPs coming through. And so in the report, we indicate now whether it's tier 1 or tier 2 next to the penalty amount. And we do have 2 brand new tier 2 stipulations presented. And otherwise, my report is as submitted.
Thank you, Chief Brereton. Chief Brereton, I don't know if you're able to see, we did receive one public comment relevant to your report from Mr. Winnick, who wanted to clarify that on page 12, the probable cause hearing, that according to the public comment, and perhaps you can talk about this, probable cause was found as provided in your report, but apparently there was another charge that probable cause was not found on.
This is actually the legal division report, so I'll clear that one up.
Oh, sorry. All right. Well, we'll hold that then. Sorry, Angela. All right.
No
Any
problem.
questions for Chief Brereton on her report? All right. Hearing and seeing none. Thank you, Ms. Brereton.
Thank you.
All right. Mr. Bainbridge, why don't you start by addressing the public comment then, please?
Yeah, it gives me something to talk about with the report. The thing that Mr. Winnick is referring to is on page 12 of the executive staff reports, where it lists the probable cause finding. And it should be labeled as count 2 on here instead of as count 1. The description of the finding is accurate. It just, in the PC report, the count that where there was a finding of PC was actually count 2. So I would request that we amend this to say count 2 here on page 12, where it labels the description of the violation.
Thank you for clarifying that, Mr. Bainbridge. Any questions for Mr. Bainbridge on his report? Commissioner Cardenas.
Yes, Dave appears to want something to talk about. I'll give him something to talk about. Mr. Bainbridge, the CSAC case, I thought it was gone. There's been an appeal filed by whom, and what are the prospects?
Yeah, there was an appeal filed, or a notice of appeal, I think it was early last month. So at this point, we're waiting for them to lodge the record with the court, and then we'll have dates set for briefing on the appeal.
And in the other case, FPPC with Mr. Kaufman, I forget who the plaintiff was.
Yeah, that's the Wallstrom case.
Yeah, is that not gone?
No, it's still around. It hasn't been heard yet. It's waiting around for a chance to get a courtroom.
Yeah, in California during COVID. Yeah. Dave, my parting shot to you, my young brother, is I want to thank you for the feedback effects earlier. You took me back. I think it was Sports Arena 1980, Pink Floyd doing The Wall opening set. Just flashback. Thank you.
Thank you, Commissioner Cardinals. All right. Moving on to the Administration and Technology Division report. Ms. Hahn.
Commissioner Baker has her hand up.
Oh, sorry, Commissioner Baker. Go ahead. You're muted though, Commissioner Baker.
Oh, golly. Here, you've got hand gestures, but no great comments. I won't make reference to whatever light show you might have had at your Pink Floyd concert, but I imagine there was one. It has to do with the Wallstrom matter, and I think this has been in your legal division reports in the past, but is this one, when it says that we're setting aside a streamlined stipulation, I mean, that's the first time I've seen that. Is it there, if you're allowed to tell me this much now, is it they're asking to set aside a stipulation that the parties had previously agreed to?
Yeah, the petitioner is a non-party to a streamlined stipulation that the commission adopted. I don't know, it looks like I believe it was last year.
Okay. I mean, that seems pretty unusual. So is that person someone who is bound by the stipulation?
I'd rather not get into the specifics of the case in an open meeting, but we can definitely talk about it in closed session if you'd like.
Probably most appropriate for me to ask you offline. I was just struck by that a stip was being challenged, because usually stipulation is everybody agreed to it, but I will, if I have further questions, I will address them separately. Thank you.
All right, any other questions for Mr. Bainbridge? Hearing and seeing none. Chief of Administration Hahn, good afternoon.
Good afternoon. I don't have anything to add to the report, but I would like to provide an update. Given the administration directions continue to be that we aim to keep employee eligible for telework on a telework schedule, and the current emergency telework policy continue to be in effect, we have extended staff current emergency telework schedule to end on June 30th, 2021, to be extended to September 15, 2021. And that's the latest update I have on staff. Thank you.
Great, thank you, Ms. Hahn. Questions or comments for Ms. Hahn? Hearing and seeing none. Thank you as always, Ms. Hahn.
Okay.
And last but not least, Executive Director West.
Hello, good afternoon. I was going to do that microphone thing to wake you up again, but since Dave's done it twice, I think it'd be too much. But so the only thing I have to report is that we did receive an opinion request. I believe all the commissioners were CC'd on it, from the California State Association of Counties, as well as the California School Board Association. That was received April 7th. Last Friday, I approved that request. So now the next step will be a memo will be presented to the commission at the May meeting. And that's when the discussion of the opinion request will commence. And then at a later meeting, the opinion itself will be presented to the commission. So that's kind of the timeline of how this will happen. Memo first, and then opinion request. So also, I'd like Jay Wairango to speak to you right now and give you an update on some of the public outreach that we're doing.
Thank you, Galina, Chair and Commissioners. Good afternoon. Jay Wairango, Director of Communications. And besides the update you gave on the technology and outreach, I will report that we are getting external and stakeholder feedback on the website. After that meeting, we subsequently got a report from the ILG, the Institute for Local Government, and we also got some initial feedback from the CPAA, and they have informed me they'd like to provide more, but we do have some initial. So we can expect that at the next technology and outreach meeting as well. And subsequently, also, we had a meeting with ILG, which of course is a representative, sort of a think tank for the League of Cities, the CSAC, and the Special Districts Association, with you and Executive Director West, and the ILG CEO and Executive Director Eric Emanuel, and other staff. We found numerous ways. It was a very productive conversation. We found numerous ways to and plan to increase our cooperation and expanded outreach through their members, which obviously is a good chunk of who we regulate. Through collective means, they're looking forward to including us on more of their panels, and they are expecting, once COVID restrictions are further lifted, hopefully, through the summer and fall and into the winter, to have actual in-person panels again and have us to take part in more and more of those. So it was a very productive outreach meeting.
Thank you, Mr. Wierenga. Questions for Jay? Commissioner Cardenas?
Mr. Chair, if I might, the ILG is an amazing organization. You go on their website, the work that they have done promoting the spirit and the letter of the Political Reform Act to their members is tremendous. I'm sure everyone looks forward to the day when the ILG and its membership can get back in person, and the ILG can continue to be a terrific partner to the commission in making sure that people understand how important, but also how relatively easy it is. We're trying to make it easier to comply and to report. So Jay, that's tremendous news that the relationship between the commission and the ILG is actually getting even stronger. The second thing I wanted to say to Jay is, as always, Jay, fight on, brother.
Fight on. Go Trojans.
That's right. Julian Calendar.
Sorry, Chair.
It's okay. Commissioner Wilson and I will.
On behalf of the chair, Bruins raise a point of order. So, with all due respect to the Trojans.
Yeah, that's right. All right. Thank you, Mr. Wierenga. Any additional questions for either Jay or for Executive Director West? Seeing and hearing none. Moving to our final item, comments and proposed future agenda items. Do any commissioners have particular items that they wish to ask be placed on a future agenda? All right, I just have one. Dave, Mr. Bainbridge, it struck me that we have a couple new members, and in light of some of the questions we had today about pending litigation, it might be, if we can, set a closed session for next month where you can update all of us and just kind of go through what each pending case is about and where it's at, and be available to answer questions. I think that's the appropriate place for most of those questions.
Yeah, sounds good. We'll prepare that.
Okay, great. Thank you for that. All right, without further ado, do we have a motion to adjourn then?
I'll move to adjourn.
All right. We have a motion and a second. Ms. Linker.
Commissioner Baker?
Aye.
Commissioner Cardenas?
Sasha, I will miss you. Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. And thank you all. I know it was a long meeting today, but a lot of good information. And Commissioner Cardenas, I hope to see you next month, sir. Take care.
I thought we were friends, man.